কি হয়েছে ওনার কি
My,
ওনার কি আছে?
Lord one X.
my lord,
Lordship kindly takes a look at the order, my lord. It was due to expire on by the end of August, my lord. It was directed to appear on 17th.
ফ্রাইডে
Thereafter, it got
আসতো।
delisted, my lord.
my lord, may I be
Friday, my lord, it's
permitted
due
to
expire
mention
on
one?
Friday, my lord. It's due.
End of August, you say?
It's not on 29th is the end of August.
31st. 31st is the end of August. 31st is the Monday.
My lord,
Sunday.
I go through the calendar.
my lord,
31st
the
is
family
the
members
Monday.
of the petitioners are suffering as the petitioner is not getting transfer from one school to another.
Please, doctor.
The petition.
For the respondent number 2, Your Lordship, the Paschim Nagar Samagra Shikha Mission. Lordship would
Yes.
recall this matter was mentioned by the other side, the efforts appearing. The can
Yes.
3 and can 4 were not available on the last occasion.
Bunch of
Yes,
that
ma'am.
were fixed on 7th September, I think.
Lordship,
Which
there
is the date
was-
fixed?
the 7th September is the other matters. In those matters, I've already filed an opposition. This matter, I have not. I'll be praying leave to file opposition in this matter as well. Your
This
Lordship.
matter is appearing under the heading to be mentioned. Mr. So-and-so, learned advocate for PB, respondent number 2. PBSSM seeks to file affidavit in opposition.
To the can application.
Can applications. Let such affidavit in opposition be filed. 2 সপ্তাহ হলে কবে হচ্ছে? By the returnable date করে দাও। 7th, হ্যাঁ। 7th এ আসছে, অন্যগুলো 7th এ আসছে তো। একসাথে রাখতে হবে না? By the returnable date, please this matter 7th.
Item 2, my lord, I am for the petition. It's a corrections of the order. My lord, at first, my lord, I tendered my unqualified apology. The quantum and the nature of corrections is a such a nature. My lord, it ought to have been come with an application. My lord, kindly see, but I have given by my learned junior the nature of corrections. So, my lord, let it be adjourned for a week. We should come with an affidavit, supplementary affidavit, or an application. Paragraph 11 is wrong. Some data are wrong.
Orders have quoted the paragraph 11.
Yes.
This matter is appearing under the heading to be mentioned. Mr. Gaurav Das, learned advocate for the petitioners, seeks accommodation to take out an appropriate application for amendment of the writ petition. And the order dated 3rd August 2026 and modification of order dated 3rd.
Simply adjourn for a week. We shall, in the meantime, take steps.
1 week's accommodation. List this matter after 1 week for it. List one under the heading.
May I seek a leave after filing the application? May I give a number to the officer of this court so that he can list it on that date?
So you place it after 2 weeks. In the meantime, you file the application and mention. 2 weeks for it list.
Grateful. আমাকে একটু এটা দিয়ে দিন, আমি এটা annex করে দিই অর্ডারের কপি। Grateful. I tendered my application.
Yes. Sorry. Next.
Please before your lord. I am for the petitioner.
Yes, there is that.
My lord, today, my lord, the alleged contemnor supposed to file additional compliance report.
My lord, here is the report.
Earlier occasion it was filed, but it was not satisfactory by your lordship.
Nothing has been decided by the resolution. Yes. Yes.
Order of your lordship is at page 58, operative portion. It was my specific case that two plots have been, construction has been made in respect of the two plots. But as it appears from page, the single annexer has been annexed in the compliance report, that in which the construction has been made and the amount has been received. Will kindly see. There is nothing mentioned. Certain amount entered in his account does not mean he has to make construction at any plot. Kindly have a look, page 56, two plots. 2183 and 2184. There is no abutment mentioned in the whatever it may be an order, but it has not mentioned that which plot, in respect of the which plot the amount has been received. Nothing has been mentioned.
My lord, my lord, in the last affidavit in compliance, in the order sheet, Alochna Shobha of dag number 2183 or 2184, Moja Uttarwad jail number is mentioned, my lord, in last affidavit. Affidavit 2.
Now 2183 and 2184 is my plot.
Follow the order and comply. Okay. Where is your sketch map?
Nothing has been supplied by your lordship. Specific guidelines has been made by your lordship.
Then how you have caused inquiry and hearing without the sketch map and inspection?
Inspection has been done, my lord.
Where is that?
In the first compliance report and the second compliance report, nothing has been annexed.
Affidavit of compliance, yes. As per order dated recently. Yeah. This is in which plot? This structure?
Structure in respect of the my plot 2183 and 2184.
This dilapidated structure is in which plot number?
2183 and 2184. It is my specific case has been made out in the writ petition.
This is old structure. This is old structure. 50 years old structure.
No.
Which has been repaired, they are saying. There is no new construction. This is old structure. The inspection report also annexed to the earlier writ petition also says that it is an old structure. Affidavit of compliance filed on behalf of the Alleged contemner is taken on record. Peruse the earlier affidavit of compliance dated 13th May 2026 and August 2026. By order dated
14th August 2020.
কি বললাম? By order dated 10th August 2026, the alleged contemner was directed to file a further affidavit of compliance since the resolution adopted on 8 June 2026 did not decide the issue. The compliance report filed this day shows that the construction is in actually repairing work undertaken on a old structure. The compliance report dated 13th May 2026. The inspection report made by Nirman Sahayak dated 5th January 2026, annexed to the affidavit of compliance dated 13th May 2026, also shows that the alleged construction is a renovation and repair work done in a structure which is 50 years old. In view of the above compliance, the contempt application being WPCRC 78 of 2026 stands disposed of. Disposed.
May I pay for only one indulgence prevent disposal of the contempt application will not prevent to challenge the decision of the
It will
authority.
never.
My lord.
It will never.
My.
This is restricted to what has been placed before this court.
Great.
Lordship, I'm for the respondent. The last order was to comply the order of the report, my lord.
What is the order?
I have got the notice only, my lord.
Notice you
The
have received.
order is in
When is the date? When is the date fixed?
date fix, my lord. They have given a report by way of supplementary affidavit. My lord, kindly have a look into the daring attitude of this Ram Pradhan, my lord. মীমাংসার জন্য ডাকা হয় এবং আদালতে সম্পূর্ণভাবে সহযোগিতা করবেন বলে জানাইয়াছেন। Thereafter, they have written that Pradhan has written that private respondent has denied that they have not done this. Therefore, if they have denied, my lord, without sanction plan it was, and the report, in this report, the page 5, this map is just copied from writ petition, my lord. Page 29 of my writ petition, that was copied. No inspection done, nothing was done.
Lordship,
They're partly compliant.
there is a
giving
lack of
notice.
time. That's why fully investigation is not yet completed. Kindly,
Inspection not completed as yet.
not yet. Kindly give some time, Lordship.
When is the date fixed for inspection? You have said that notice has, notice has been
Lordship,
given to you.
Today, I have received.
Notice, my lord, 11th August 2026. Date was fixed 13th August 26. But my lord, here it is written, my lord, that notice is not with me, with my client. Here it has been written, my lord. Kindly have a look into page 5, 6, and 7 of their report. মীমাংসার জন্য ডাকা হয়, in a contempt proceeding মীমাংসার জন্য ডাকা হয়. Is that the daring attitude of Pradhan, my lord?
Lordship, this is for complying the order for both the parties.
মীমাংসা?
Yes, yes. Nirmal is the respondent.
No, my
No,
Lordship.
Nirmal Sikdar is the petitioner.
Petitioner.
And my lord, next page, kindly have a look into. Next page. Completely wrong report. তাহাকে ডাকা হয় এবং বিষয়টি মিটিয়ে নেওয়ার জন্য অনুরোধ করে, মানে কাইন্ডলি হ্যাভ এ লুক ইনটু ইন আ কন্টেম্পট প্রসিডিং বিষয়টি মিটিয়ে নেওয়ার জন্য। Demolition I have prayed without having sanction plan. Last portion, my lord, kindly have a. যাহারা উক্ত কাজটি করেছে তাহারা পরিষ্কার করবেন. That means this respondent has denied. Therefore, there is no but to the Pradhan.
All has denied.
Nirmal is the petitioner. How he can deny? It is completely
Yes, Lordship.
false.
Petitioner also denied that still
have
it is
not.
pending in the court, High Court. That's why
No, petitioner denied what?
What?
petitioner have denied that.
Denied to take part in the inspection or denied to settle the issue. If denied to settle the issue, he is right.
Not for settle.
He says that the matter is pending before the honorable court, so there is no question of settlement. Now you proceed with the inspection and
Lordship,
hold
kindly
the
give
hearing.
more time
If you
for.
find that there is some illegality, you take steps accordingly.
And Lordship,
What about the respondent? They have appeared.
Yes. My
only
lord,
3
page
persons
6.
have appeared. Page number
Page
6. Murari Mohan Chaudhuri, Shivaprasad Rai, and Lordship Arunangshu Chatterjee.
Supplementary affidavit filed.
বিতর্কিত বিষয়টিতে জড়িত থাকেননি বলে জানান. Therefore,
given
private
their
respondent
statement.
has denied that they have not done this. Therefore, what is the problem of
Ashun.
Pradhan? Can be
Supplementary affidavit filed by
Lordship, kindly give some time for more investigation of this matter. Inspection.
certainly. You have given a copy to supplementary affidavit copy. Copy you have given.
I have served.
Yes, ma'am.
Lordship, kindly pardon me. There is a instead of writing affidavit of service affidavit, supplementary affidavit is written. Lordship, kindly pardon me. It's a clerical mistake.
এখানে correct করা যাবে?
Supplementary.
একটু correct করা যাবে এখানে হেডিংটা? No, বলছিল affidavit of compliance লিখবে। What this is affidavit of compliance?
Affidavit of compliance, Lordship.
তার থেকে কি এগুলো ওঠে? হ্যাঁ? On the prayer of learned advocate for the alleged contemner, leave is granted to file supplementary affidavit. Supplementary affidavit filed on behalf of the alleged contemner is taken on record. Then the advocate for the petitioner, alleged contemner submits that the supplementary affidavit is in a way an affidavit of compliance which was directed by this court to be filed by the alleged contemner. Copy served.
And my lord, I'm also denying that it is not compliance.
Learned advocate for the alleged contemner seeks accommodation to comply the order of this, submits that notice has already been issued. He seeks further accommodation to comply the order of this court. বলুন তো 2 সপ্তাহ পরে 8th September.
Well, kindly 9. Kindly 9th. I have some problem. 8th September.
9.
For the board list.
For the petitioner, my lord, it is notional benefit matter, my lord, is similar order passed by your lordship. Twenty 2016 selection process, notional benefit from
This has been disposed of. Matt
Mat, lordship, mat number?
1896.
No, lordship, this thing. Lordship, one difficulty is, list that is annexed in the repetition is of 738. The 738 candidate is from the recruitment process of 2020. One name I could find out in page number 33, third name, Yasmin Parveen. So that is not matching with the appointment letter, the spelling. So if there is the admit card, I could have matched with the roll number, but the admit card is not annexed. If that document comes, lordship, I could enlighten your lordship that whether this is the same candidate. So they have been appointed in the which process. The appointment letter
Serial
is
number?
lordship, page number 33, third name, Yasmin Parveen. Could find only one name. And the repetitioner is Yasmina Parveen. Yasmina Parveen, right? So the spelling is not matching. I don't know because the roll number I could not match. There is no
No, it is Yasmin Parveen.
Yasmin Parveen. The petitioner is also Yasmin Parveen. The spelling is different.
Oh.
So by matching the roll number, I could, but the admit card is not annexed. Not even the training qualification at what, which year they have been trained, whether B.Ed or D.El.Ed. Them come with the documents, lordship. I will
Okay.
copy to me.
Where is this? Yasmin. Mr. Kaushik Chaudhary, learned advocate for the board, submits that there is a mismatch in the name of the spelling of the petitioner. The petitioner be directed to furnish the admit card, furnish her admit card for the recruitment process in which she has participated, which will enable the board to further enlighten on the prayer made by the petitioner. Enlighten the court. In view of the above submissions, petitioner is directed to produce her admit card on the returnable date, filed by way of a supplementary affidavit, annexing the admit card. Let such be filed within a period of 2 weeks. 2 সপ্তাহ পরে file a supplementary affidavit annexing your admit card. Take this back. এইটা দিয়ে দিন অর্ডারটা কপি।
There's an order in my Even my lord, I am
My
appealing
lord, I'm for the
petition.
state, my lord. On the last occasion, my lord, lordship had directed me to, my lord, find out from the department, my lord, as to the status of the, my lord, the petitioner. My lord, the communication that I have received, my lord, is not to my satisfaction. Lordship will kindly, my lord, have a, this is what was sent, my lord, to me in my personal WhatsApp number. This is not to my satisfaction. So what I have asked for, my lord, is for the file to be reviewed and, my lord, to file a fresh report. Lordship will kindly take para 10 only. That will, my lord. It says, my lord, that it was dissatisfied with the papers and could not have. Now, this has to be, my lord, a reasoned order. It cannot be like this. So, I've, my lord, asked them to file a, my lord, a proper report, not in this, my lord, lackluster format.
My lord, in terms of annexure P7 of my lead petition, kindly come to page 55, my lord, for a moment, my lord. The chairman in charge, Paschim Medinipur District Primary Council, my lord, has sent the, my lord, after verification at top, my lord. So after verification and examining all the papers available to me, I decided to send the name of the petitioner Nitya Gopal Pal to the Commissioner of School Education for necessary approval, my lord.
And don't please disturb me.
For necessary
Yes,
approval.
approval of the appointment.
I will go to the bar library and meet you once.
So therefore, my lord, kindly direct them, my lord, to approve the appointment of the petitioner, nothing else, my lord.
Please understand. I don't know what that matter is going on.
No, good luck. Best of luck. I hope you will.
Because if recent order pass, then petitioner have to again come. Why recent order is required, my lord? Kindly see from the, my lord, from their notification, my lord, memo, my lord, page 55, my lord.
It was dissatisfied with the papers.
Petitioner is 55, 6 years old, my lord. Says he is suffering from the year 2004, my lord.
Saurabh Sengupta, learned advocate for the state respondents, seeks a week accommodation to file a report next week. Since the instruction received is not satisfactory. Next week. Topic.
7 days time may be given. I will come back with a proper report, my lord. This is not. Obliged, my lord.
A time for the petitioner. On the last occasion, that is on Friday, the matter appeared before your lordships. Kindly come to page 35 once. In Rajkumar Ghosh matter, by the dint of the order of the dated 26th September, the petitioners are given appointment. Page 35. And kindly see the writ petition once. I have the copy of the writ petition wherein the name of the petitioner is at serial number 4. This is the copy of the writ petition.
35. Rajkumar Ghosh, you are petitioner.
Rajkumar Ghosh petitioner and your present petitioner is serial number 4. After getting appointment in the year 2022, Rajkumar Ghosh filed a writ petition seeking increment benefit, and kindly see your lordship's own order.
Then
This order passed by your lordships giving benefit.
notional benefit has been given.
Yes.
To Rajkumar.
Yes. Similar case, similarly situated.
Yes, Mr. Chaudhary.
May I hand over the list? This should have been annexure of the repetition. This is the server copy. Here the petitioner name is reflected. Page number, kindly come to page number 3, lordship. The roll number, the name has been print out, lordship. I have marked it. This is the roll number of the petitioner. He has got, he was recommended for 2016.
2016.
This is the list, lordship. That should have been a part. So there.
Then he stands on the same footing as Rajkumar.
Yes. That's why I have collected the copy of the writ petition.
Okay. Affidavit of service filed on behalf of the petitioner is taken on record.
I believe, my lord,
by
the
the
state is also unrepresented in this, my lord.
Okay, you will represent by the present writ petition this petitioner was not a petitioner in Rajkumar Ghosh writ petition, because in that writ petition 227
in 2022 writ petition
no
number.
no in Rajkumar Ghosh
Yes.
there were certain petitioners whose name were expunged by the court. 227.
The coordinate bench was of the view that they have to file
Separate. Okay. For that reason,
Yes.
by the present writ petition, the petitioner seeks for notional benefit as assistant teacher in primary school with effect from February 2017 and consequent release of all service benefits, including revision of pay and annual increments by refixation of the scale of pay. The petitioner contains that he participated in the recruitment process of 2016. The petitioner joined as primary school on the basis of which notification?
Notification dated
24th
20th
November.
Page 26. The list
No. Of the DPSC.
16 November. 16 November.
24 November. Page 33.
Yes. 24 November.
Primary school. The petitioner joined as an assistant teacher of a primary school under DPSC Murshidabad on the basis of notification dated 24th November 2022 issued by chairman in charge. Chairman.
Page 33.
Chairman DPSC Murshidabad pursuant to order passed by a coordinate bench of this court in WPA 20594 of 2022 within bracket Rajkumar Ghosh and others versus State of West Bengal and others. The petitioner prays for notional benefit as assistant teacher of a primary school from February 2017. Page 60. Who is for DPSC Murshidabad? None appears on behalf of DPSC Murshidabad. Service affected?
We have served.
Despite service, none appears on behalf of DPSC Murshidabad and the state. Mr. Saurabh Sengupta, learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. Let the name of Mr. Sengupta be regularized by the concerned authority. Learned advocate for the petitioner is directed to hand over a copy of the writ petition and its annexures to Mr. Sengupta. Mr. Sengupta leaves the matter to the discretion of the court. It is found that the present petitioner stands on the same footing as of the petitioner in WPA 23031 of 2024. Accordingly, page 61, same para 9. Disposed of. শিবানী বাবু এইখানে মল্লিকা মাহাতা ভার্সেস স্টেট অফ ওয়েস্ট বেঙ্গলের জায়গায় রাজকুমার ঘোষ, ঠিক আছে, এই রিট পিটিশনটা এইখানে আছে না 205 না এইটা 2031 দুটোই রাজকুমার একটা আগে ফাইল করেছিল, রাজকুমার পরে আবার নোশনাল চাইলো, ওটা থাকবে তারপরে ও সাবমিশনে 23031 এই জায়গাটা disposed of. Yes.
24th.
Okay. He files, Mr. Chaudhary Reti, he files a copy of the notification under memo number 1959/WBBPE/2022 dated 24th November 2022, which is taken on record. Yes.
Item 9, my lord, I am for this. I am appearing on behalf of the petitioner.
Well, I am for the school headmaster.
Lordship, these are my affidavit of services. I have served all the respondents,
Respondent number 8, headmaster.
along with the notice for upgradation of this matter, Your Lordship. Lordship, here, my lord, the first one is the notice which I have served upon the respondents for upgrading the matter. Lordship, and the other one is the affidavit of service. Lordship, here, the this petitioner was appointed on 30th of January 2006 as additional para teacher in Jangalpara, Bhogolacharan, Kundu Memorial High School. And the service has been confirmed as a para teacher in the same school on 8/6/2017, Your Lordship. Now, everything was going well, Your Lordship, till September 2025, Your Lordship. Here, Your Lordship, I made a complaint against the headmaster of the said school, alleging some illicit proposal and some proposal against me, Your Lordship, which I objected to that. So now, Your Lordship, the headmaster of the school debarred me from signing the attendance register with effect from October 2025, Your Lordship, without assigning any reason. Now, kindly come to annexure P3 at page 14, Your Lordship, of my writ petition. Page number 14, annexure P3, Your Lordship. This letter was written to the headmaster by the circle project coordinator, Urshura South Circle, Your Lordship. This letter was never intimated to me, Your Lordship, to the headmaster, Jangalpara BCKM High School, regarding unauthorized leave of para teacher Srimati Momita Shamanto is the petition here. With reference to memo number this and this dated 27/1/2016 issued by the district project officer, SSM Hooghly, it is hereby informed that Srimati Momita Shamanto, the para teacher of your school, has availed unauthorized leave beyond her sanctioned leave. You are therefore requested not to allow her to join her duties without obtaining proper approval from the higher authority. Necessary in this regard may be taken as per the instruction of the said memo. So, Your Lordship, my contention before Your Lordship that I was suddenly debarred from signing my attendance register since October 2025, Your Lordship, and I am not getting my salary since September 2025. They have said this letter was never intimated to me. It was the internal communication between the headmaster and the circuit project coordinator, Your Lordship. They have debarred me from attending my classes. Lordship knows that if I was debarred from attending my classes, there should be a termination or suspension, any of that sort. Or show cause notice is to be issued for my unauthorized absence. Your Lordship, I'm putting this question to myself, Your Lordship, before giving any opportunity of hearing, Your Lordship. They are casting stigma that I have availed the unauthorized leave. Where is the paper? There is not a single scrap of paper which says that I have overstayed of my sanction leave, Your Lordship. They cannot show it. They cannot issue any show cause notice. They are casting stigma on my Your Lordship, on my character or on my part that I have overstayed for that leave. But there is no scrap of paper which can show that I overstayed there. Your Lordship, there is no show cause notice, no disciplinary proceedings against me, Your Lordship. So they cannot debar me from that. Now, Your Lordship, I made many representations before the authority concerned. Just my prayer before Your Lordship to let me join my duty so that I can attend my classes and get my salary, because this is my only livelihood, Your Lordship. Your Lordship, my livelihood is at stake, Your Lordship. After so many representation to the authority concerned by the petitioner, by the learned advocates, Your Lordship, at last, Your Lordship, this headmaster of that said school has given me a letter dated 8/12/2025, which is annexed at page number 27, annexure P5. Lordship, kindly come to the last annexure P5. Maloniya Srimati Momita Shamanto. Lordship, kindly come to first, second, and the third paragraph. Apnar beton bondo o hajira. My Lord, kindly come to the last paragraph. Third. আপনার বেতন বন্ধ ও হাজিরা খাতায় সই না করতে দেওয়া যে অভিযোগ করেছেন সেই সম্পর্কে জানাই উক্ত বিষয়গুলো মাননীয় অবর বিদ্যালয় পরিদর্শক পরশুরা দক্ষিণ চক্র এবং মাননীয় জেলা শিক্ষা অধিকর্তা সর্বশিক্ষা মিশন হুগলি মহাশয় এখতিয়ারভুক্ত অনুমোদিত অতিরিক্ত দুটি গ্রহণ সংক্রান্ত কারণে মাননীয় অবর বিদ্যালয় পরিদর্শক পরশুরা দক্ষিণ চক্র মহাশয়ের নির্দেশ ক্রমে মেমো নম্বর দিস এন্ড দিস ডেটেড 30/10/2025 the date I was debarred. পুনরায় বিদ্যালয়ে যোগদানের জন্য আপনার I'm sorry, Your Lordship, I'm just কর্তৃপক্ষের প্রাপ্তির প্রয়োজন মাননীয় জেলা শিক্ষা অধিকর্তা দেশ এন্ড দেশ মোতাবেক মাননীয় অবর বিদ্যালয় পরিদর্শক মহাশয়ের উপরিযুক্ত আদেশনামা অনুযায়ী this and this is to be done, Your Lordship. The headmaster is writing a letter to me, Your Lordship. The headmaster is the best person, is the authority concerned who can sanction my leave, who cannot sanction my leave. So there is no scrap of paper which shows that I overstayed my sanction leave or any proceedings. That has to be a show cause notice at least that yes, Ms. Shamanto, you have overstayed your sanction leave. You are required to give a reply to this show cause. No, nothing, Your Lordship, of that side. Only I was debarred from attending my duties. I am restrained to do my class, attend my classes, and I am not getting my salary since September 2025. So I made a representation. All this representation proved to be futile and nugatory, and they are shifting burden to the circle project officer that they will give me the অনুমোদন or approval to join my duties. That cannot be, Your Lordship. That should be a disciplinary show cause notice at least.
Lordship, may I submit? So, Madam, finished? Lordship, she is a para teacher. She is not an assistant teacher. She is governed by the scheme Sarvashikha Mission. She is a para teacher, additional para teacher in the school. She is governed entirely by the circle project coordinator, because the school authority or school management has to rely upon the instructions of the circle project coordinator regarding the leaves. Lordship, kindly see, on 11th of September, we have written to the circle project coordinator regarding her availing the leave. And she is, my lord, I will not say as per the instruction of her client, she is telling a lie. She is telling that no intimation of the order of the circle project coordinator was not intimated to her. She was in the school. In presence of two witnesses, she refused to accept. Kindly see the bottom. It was communicated to her. She refused, and she took it personally. I am a headmaster of a school. She is an additional para teacher. And she is taking the issue personally, personal vendetta, lodging some complaint, frivolous things, because my hands are tied. She is not governed by anything regarding the school because it's a separate scheme, Sarvashikha Mission. Sarvashikha Mission, we have to rely upon the circle project coordinator's director.
PBSSM.
I'm appearing for the state matter.
And this is the status report, Lordship, we have sent to the circle project officer regarding our she suddenly stopped coming to the school. We returned to the circle project coordinator, the additional para teacher is not coming. Now they have
come to page 7.
Lies after lies she's telling. সর্বশিক্ষা মিশনের ব্যাপার। ঠিক, নমস্কার। ডিপার্টমেন্টের এই মেমোটাও আছে।
Service you have not served upon the PBSSM.
Lordship, I've served everybody, the affidavit of service.
Not there. It's not there.
It's a statutory authority. We are governed by.
However, he is a party district project officer. You have not served.
District, the circuit project coordinator, district project officer, respondent number 4 has been served, Your Lordship.
What about the district project officer?
District project officer has been served, Your Lordship.
Where is that? I'm not getting them.
State project director.
You have sent to the headmaster, to the district magistrate.
Circle project coordinator has also been served, Your Lordship.
Circle project
7.
coordinator. What about the district project coordinator? Who is the head of this authority? He says that district project officer is the
Yes.
head who appoints the para teacher. Para teacher comes under him.
Scheme.
She's a para teacher, not the additional one. She's a para
But
teacher.
where is the service upon the district project officer? He is the answering respondent. Affidavit of service filed on behalf of the petitioner is taken on record. By the presented petition, the petitioner seeks direction upon or who appears in the High Court on behalf of PBSSM.
Not because new panel has not been.
Complete the service and come back. Seeks direction upon the respondent authorities to allow the petitioner to sign the attendance register and perform her normal duties. Ms. Wensol, an advocate for the petitioner, submits that without any rhyme or reason, the petitioner has not been allowed to sign the attendance register. The letter of page number Circle Project Coordinator, Pursura South Circle, the observation in letter dated such and such 30th October 2025 of project Circle Project Coordinator Pursura South Circle is without any basis of unauthorized leave is without any basis. Learned advocate appearing for the school submits that the school has taken steps seeking for instruction of the unauthorized leave availed by the para teacher, the petitioner being the para teacher. The headmaster of the school has also intimated the petitioner to obtain approval from the higher authority prior to rejoining the post. It is found that service has not been affected upon the district project officer PBSSM. The report filed by the state through who is filing this report?
No. Yes,
District.
District.
This is district education officer, madam.
District education officer.
District education officer.
District education.
Paschim Bongo.
District education officer মানে project officer এটাই তো।
You cannot represent district project officer. There is separate panel for that.
Don't know, madam. We have been requested, madam, to appear. Madam, we have been.
They can request, but that is a separate body.
Yes,
The
separate body.
state cannot come with it. They have a separate panel.
Panel. So it is a central government scheme. সর্বশিক্ষা মিশন।
It is the respondent number 6, madam.
Respond number?
6.
to District Education Officer, Paschim Bongo Sarvo Shiksha Mission, Hubli, is taken on record. Give a copy to the learned advocate for the petitioner.
Correct.
It appears that service has not been affected upon respond number 4, District Project Officer, Paschim Bongo.
So नाम दे दीजिए.
These are both 4 and 6 are same.
No, Lordship. She has made party. There is no, I don't know who is district education officer, because there is a DI or district project officer. District
Education officer is there.
No, there is no post. Because I used to appear for.
In 4 and 6, it is the office of the district magistrate.
Yes. District project director is the DM. And district project officer is a ADM rank officer who has been deputed with the additional duty of district project officer to conduct Sarvo Shiksha Mission.
Okay. Stated reporter now, dated 6th August 2020, taken on record. It is found that service has not been affected upon district project officer. Learned advocate for the petitioner is directed to serve upon district project officer and file affidavit of service on the returnable date. Is this matter of 2 weeks?
Let my instructions be kept on record, Lordship.
I'm taking this, but you can file a comprehensive.
Yes, a comprehensive report
annexing
with
all
the
these
affidavit.
documents.
With affidavit. Liberty will given, Lordship.
Respondent number, your
8, school
is
authority.
directed to file a report in the form of affidavit on the returnable date. The headmaster is respondent number 8.
Respondent number 8.
After 2 weeks per draft. Serve upon the district project officer.
Lordship,
Lordship. Matter is returnable not?
After 2 weeks.
After 2 weeks.
Lordship, can it be after 3 weeks? Because it's.
Everything is ready, you file your affidavit. Let the project officer say and come and say what is his stance.
Lordship. Grateful, dear Lordship.
I appear on behalf of the state that on the last occasion, that an affidavit was filed. Lord, it had, Lord, in its cause title, since all the matters were being heard analogously, the cause title of all, Lord, the writ petitions. But a single copy was filed inadvertently. Lord, my learned junior was under the impression that since analogous matters, the matters are being heard analogously, only one copy is required to be filed. On the very next day, Milord, the competent officer who affirmed the first affidavit, Lord, he came and he affirmed, Milord, the affidavits. Lord, those are identical affidavits. Copies thereof have been circulated. Lord, I shall file, Lord, copies thereof to keep the record straight. Lord, would kindly permit me to place that affidavit, Milord, because that answers, Milord, my Lord's queries. And the queries which are germane, Milord, for adjudication, albeit, Milord, at the interim stage. Whether that be after the petitioners make submissions, or whether, Milord, if my Lord thinks, Milord, that the petitioners have made submissions and the state was on its legs, then, Milord, I can place my opposition, whereafter, Milord, the petitioners
I
can
think
file
that would not be proper because that was for the interim stage. State has now filed a complete affidavit to entire its petitions. So let us proceed on that basis, Your Lordships. That's one of the issues.
That's why I told you that since 1.5 days have been invested on this hearing, so we conclude the hearing by way of an affidavit. That's why if you intend to put in anything which you have left out, so that after I go for reply, you conclude that. If you say that some other facts have been stated, which has not been indicated at the time of when I was hearing the interim matter, you can place those points so that we can also take a response from in reply. That will be concise.
Now, Lord, since petitioners are making submissions, Lord, I shall reply to that. To that, Lord, they can always, Lord, give a retort. That is, Lord, how, because now my Lord, is hearing it.
Because I think, Lord, after the affidavit.
Your replies?
Lord, this is in regard to
19417, the first matter, Bani Chakraborty.
No, Malad, this is
reply. দেখো 1903.
এগুলো ঠিক ফাইলে দিন।
Mr. Mojumdar is appearing in one item.
I'm appealing in one.
Last one. I'm coming to that. 19720. Mr. Ahmed.
অসুবিধা হবে ট্রেন কর মাঝে মাঝে টেপ তো মারতে যাবি
1035
হ্যাঁ
আচ্ছা গেলে
10.
मतलब this is in regard to 19893.
893.
May I submit my reply? ও বাবা রে ঠিক আছে কোনো অ্যাডিশনাল পয়েন্ট
ঠিক আছে আপনি একটা করে রাখুন না উনি দিচ্ছেন
19893 Nishtha Devnath and others
19720.
I believe, my lord, the state respondents would receive their submissions in, my lord, whatever the pleadings they have made in the counter affidavit, subject to correction.
তাই
except the law
ও তো সব সময় আছে
দেখো 19857.
হ্যাঁ হ্যাঁ
19857 who appeared?
অনলাইন তো জুনিয়রকে দিয়ে দিয়েছে
Mr. Dasgupta appeared. Your reply?
Yes, my lord.
Oh. Yes. Who will argue first, Mr. Sarna?
আসলে ওদের প্রবলেমটা হচ্ছে জুনিয়র আসছে না অনুজিৎ মুখার্জিকে দেওয়া হয়েছে
ঠিক আছে পেয়ে গেছি
আজকে দিচ্ছে তোকে তো তুই পড়বি কখন
সফট কপি চাইলাম
অবশ্য তুই অমনি হ্যাঁ Let me start you.
After Mr. Shanal concludes, my lord, I will make.
and so regard to 19903
19903, yes.
অব্রতোষ
I've already.
yes
Reply has been filed.
reply opposition all are complete readings are complete 19417 ও আমি নেই
You are in
Now may I? Namalad, I will so far the pleadings are concerned because pleadings are vital in this matter, my lord, in respect of all the matters. I will, my lord, I will take your lordship to the pleadings paragraph wise. A read petition, opposition, and reply. 19893.
19893 টা দিন
My lord, I to concise the matter, my lord, I will argue point wise. পরে
বাঁধা থাকে হ্যাঁ
এমন কিছু না
19417 who is
9417.
Mr. Sannal will argue on this. Okay. 19893.
My first point, since affidavits are complete, my lord, we have been able to know the stand of the state and now so my first point, your lawsuits in the read petition which you have taken, that very identification and determination of surplus teachers and deficit teachers are illegal and contrary to law. This is our first point. From the very victor losses, kindly remember. And if goes to the root, SOP is there or not, my lord, irregularity on the SAP, that's according to me. SOP also says that
yes.
So this is SOP also says that they will follow the for identification of the excess staffing, that's the language used in the SOP, under the Right to Information Act, in terms of the Right Education Act, sorry, Right to Education. Similar, in order to, paragraph 7 and 8 of the writ petition. So the factual background, your lordships, I will take.
Mr. Chaturvedi,
Yes, ma'am.
can you just provide a copy of the affidavit in opposition in this item?
That I hand over my copy to my daughter.
আমাদের extra copy আছে দাও। No, 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 আচ্ছা copy।
I'm taking minus kindly because after Mr. Sagnal finishes, then I will have the chance. I thought to speak.
Okay, okay.
Finishing that.
Yes. 8 or 9? 19893. Mr. Sannal, have you got a copy of that?
19893 আমাদের একটা copy। Affidavit statement।
No, no, it has actually. All that this is, as I said, Milord, composite was
Okay, no, I have separate files, so I'm searching for the affidavit in opposition. Okay.
Got it?
Yes, yes.
Well, first, by the writ petitions, paragraph 7 and 8.
Kindly ignore the markings.
Okay.
ও তো থাকবে ছেলে কেউ কিছু মনে
7 and 8.
8
But I'm taking my lord shortly.
7 and 8.
This is in regard to my first point, that very identification and determination of third class teacher and decibels teacher are contrary to Act, rules, and the Constitution.
Yes.
Paragraph 7. As of 31st December 2025, there are 3652 number of recognized and aided primary or pre-primary schools in the district of North 24 Parganas, South North 24. There are 57 circles for the purpose of primary education within the district. The petitioner crave reference to a list prepared showing the circle-wise number of primary schools within the district of North 24 Parganas. This number of recognized schools are according to circle-wise, divided according to the jurisdiction or area of the circle-wise. Then, your lordships, for the purpose of convenience and appreciation and perception of the contention and submissions of the petitioner, based on facts in regard to the present petition by this honorable court, the following instances with reference to particular schools are reproduced below. Kindly see the very first school, my lord, Satyendra Bose Shriti Primary School, Panihati Circle. Present strength of the students 213. Present strength of assistant teachers 9. Head teacher 1. My lord, we could not, my lord, at that point of time, my lord, plead class-wise student strength. That we have given, my lord, in this reply, because we could not get it at that point of time. Then your lordships will find 2. Madanpur SS Free Primary School, Amdanga Circle. Present strength of the students 39. My lord, I have given class-wise students enrollment. Or your lordships, somewhere it states gradation, class is called gradation. Then you also will find present strength of assistant teacher 3, head teacher 1, number of surplus assistant teacher 2. Therefore, out of 4, 3 plus 1, 2 has been declared to be surplus. As your lordships in the first school, your lordships will find, I will take your lordships after that. Then third, Amdanga, Dipil Primary Schools. Total enrollment of the students, 65. Class-wise enrollment I have given your lordships. Present strength of assistant teachers 3, head teacher 1. Number of surplus assistant teacher 1. Balugachi Free Primary School, Banipur Circle. Present strength of the student 103. Present strength of assistant teacher 2, head teacher 1. one has been shown deficit. These are, I will take your lordship subsequently to the what they have said in regard to this. Rajballabhpur Junior Basic School, Banipur Circle. Present strength of the students 340. Present strength of assistant teachers 13. Head teacher nil. Number of surplus assistant teachers 3. Number of deputed teachers 1. Number of special educator 1. The breakup according to class wise we have given in the supplementary affidavit. These are the pleadings, your lordship. If your lordship kindly take up the paragraph in regard to these facts 7 and 8, my lord, of the writ petition, your lordships will get it. I just take your lordships to that. Paragraph 16.21 of the affidavit in opposition.
Yes.
I just tell us. Kindly, I read out. With respect to the allegations made in para 1 to 8 regarding the petitioner's status as assistant teachers under the No.24 Parganas DPSC, illustrated with reference to the petitioner number 87, Ms. Devamita Pal, who joined Satyendra Bose City Institution such and such date, and other named school, including Akholi GSPA Primary School, Banipur Circle, admitted being matters of record. The petitioners are duly appointed assistant teachers, and that Mrs. Devamita Pal joined the school named on that date stated. It is denied that she or any other petitioner is entitled to the reliefs claimed. Well, that's different issue, relief. Relief is barely denied, but facts are admitted. What I have stated in paragraph 1 to 8 are admitted. Now, your lordships also find the very next paragraph. The rest in the paragraph 16.2, my lord, that Demarar point I will deal with at last, your lordships. Kindly see the next paragraph, paragraph 16.22. With respect to the allegations made in para 6 and 7, again, my lord, they say, because with respect to allegations made in para 1 to 8, they have dealt with and admitted 16.21. Again, my lord, out of that, again 6 and 7. Regarding alleged issuance, distinct SOP at level, field level, and cut-off dates, both dates have been given, denied that memo admin dated is an independent of third SOP. But I do not find, at least in my writ petition paragraph 7 and 8, any allegation in or statement in regard to SOP. Kindly your losses. Para 7, 8 I have placed. Only Malat para 7 and 8, if I am not wrong, only this factual basis I have said, and they have admitted. So this reference, my lord, I probably, my lord, hurriedly done or something, your lordships. They have in respect to the other writ petitions, probably. So this is not in relation to my writ petition. But so for 16.21, D3 clearly mentions my writ petition number, page 17. Kindly see your lordship, page 17. Just above 16.21, D3. This deals with my writ petition. This is composite writ petition. Affidavit, I'm sorry. So, Malak, this is, I think, copy paste or something somewhere happened. This doesn't relate to my petition.
In para 6, you have stated of the SOP.
Para 6 I have stated, but yes. I am placing 7 and 8. Malak, kindly see with 16.21, 1 to 8 they have dealt with. They do not say, my lord, in but even then, Malad 6 and 7, that I will, Malad, not factual, present factual background they are dealing with. I will come back, Malad, when I will take your losses to the SOP. Malad, kindly take your losses and now reply, because I am on the point of, Malad, surplus at page 8 small g, page 6 of my reply, dealing with 16.21.
8.
8G.
Yes.
Kindly see. My lord, in the read petition, we gave the figure 3652, number of recognized school. My lord, this has reduced in the district. This has, according to us, come down to 3478. My lord, they admitted it 3652, but that's not the correct situation. Number of the school have been reduced. Now, then your losses will find the total sanctioned post of assistant teacher in all recognized primary school is 17,500 as of today. The total number of assistant teachers including head teachers in the recognized primary junior basic school within the district is 19201. Your losses will clearly find that sanctioned post and the number of teachers appointed already and working varies. Without the sanction strength, they have been appointed. My lord, I am not taking any point that, but I am giving you losses the figure. Therefore, my lord, as of today, 19,201 teachers are there working, assistant teacher, including head teacher. Zero enrollment school within the district is 27, having 78 assistant teachers. Prior to passing the interim order by this Honorable Court on 15th August 2026, all the said 17 assistant teachers of zero enrolled school have already been transferred without completion of the exercise of identification or determination of the surplus teachers. My lord, I am not taking too much on this point that they have, my lord, transferred the teachers who had the zero enrollment. This is not my case. But a little bit of case is there. Zero enrollment teacher schools, teachers already there 78, they have to be transferred. They can't sit idle. It cannot be. But where they have saying, that point remains on the basis of identification of surplus. Where you have given on what basis, how do you have identified and determined surplus and then transferred? Surplus means the school where you have given. I will take your losses to that. Now your losses will find the next paragraph H. The aforesaid data of number of recognized schools, number of sanctioned posts, and more particularly number of assistant teachers in the recognized group clearly suggest that there is no surplus teacher in any school, and therefore do not suggest any rationalization of the deployment or transfer of teachers from one school to another school, in as much as 3478 number of recognized schools are having 2086 classes.
Yes.
Malad, we have multiplied 3478 into 6 classes for each school, whereas the number of assistant teachers is less, that is 19201. Malad, if we go by class as a unit, Malad, therefore the teachers are less in the schools. Then where is the necessity of deployment? Because any deployment of transfer will affect the other school, because already they are suffering.
But the sufferance in the other schools might be more where there is more students.
Exactly, your losses. That's my point. Therefore, I am dealt with this Malad in affidavit. I will give you a loss. In the writ petition itself, I have dealt with. Malad, what I am trying to make out, your losses. Suppose, Malad, in one school, first, Malad, how identified, that's the point. This goes to the root. I will take your losses, how they have identified. They have identified school-wise. Affidavit is clear on that. Not class-wise. If it is school-wise, that makes the entire thing vitiated. It should be class-wise. Suppose your lordships, I take an example. If your lordships kindly come to, I placed before your lordships 132 page of the writ petition. This is my basic point in the writ petition. SOP comes later because SOP says they will follow RTE Act. SOP doesn't determine it. Identification to be made by the council or the local sub-inspector of schools. Yes, 132. What I'm trying to make, your lordships. Madanpur SS Pre-Primary School, Amdanga. Present strength of the student 39. But class-wise, pre-primary 8, class 1 12, class 2 5, class 6, class 4 8. Now 5 have been included. That's why I have multiplied by 6. Present strength of assistant teacher 3, head teacher 4. Number of surplus teachers 2. Well, they have published a list. I will show. They have admitted also. I have annexed 1 because all 57 circle malad we cannot. We have not got it all 57, but some of them we have got. So therefore, what is the basis, your lordships? School-wise. Because they go by, according to me, that is misinterpretation or understanding. They go by our RT Act. First, 1:30, 62. Here 39, above 30, but below 60. So you will get 2. The point comes up, my lord, how the 2 teachers will teach 5 classes. So this should be, my lord, class-wise. And that's the law, my lord, under the RT Act I will show when I will place the law, my lord. Factual is this, my lord. Therefore,
Yes.
that's why, my lord, I have divided, my lord, 3478 multiplied by 6 into, my lord, requirement of teachers. Class-wise. At page 6 of the reply. That should be the, my lord, ideal, my lord, correct situation. My lord, kindly see, my lord, then page 7. This also presupposes and suggests requirement of recruitment of assistant teachers in primary schools, which forms part of the infrastructure as envisaged in section 8D and 9M of the RT Act 2009, and not the purported rationalization by way of deployment or transfer of assistant teachers. Such purported rationalization of deployment of transfer of teachers cannot wipe out dearth of teachers in spite of existence of classes having sufficient number of students to be imparted education. These constitute failure on the part of the state government to provide infrastructure within the meaning of the RT Act 2009. Now, my lord, I have added somewhere, my lord, in the next paragraph also. Article 21A, right to education up to class 8 is secured, and that's why 2009 Act. Now visualize, my lord, the situation in any of the one school I have given instances. If the other 2 each has declared surplus, even if your losses see 5 classes or 6 classes up to 5, how the other classes students will be taught? By whom? I'm putting a question to myself. Well, this has been very nicely answered by the 2 or 3 high courts. I will place, my lord, when I will place the judgment. This is contrary to law. You can't go on school-wise. You have to go class-wise.
Yes.
This is, my lord. Now, your lordships, kindly, my lord, I take your lordships to paragraphs, the next paragraphs, your lordships. Just a minute. My lord, paragraph 26A to F. This I have narrated by way of submissions on the basis of this fact. Paragraph 26A, my lord, page 136 of the writ petition.
A.
Page, my lord, 136 of the writ petition.
Yes.
Now, your lordships, kindly consider this. Under the said norms and standards for a school, number of teachers for 1st class to 5th class in respect of admitted children up to 60 is 2. Well, I have quoted this from the schedule of the RT Act. Exactly, my lord. What is? Now, this has been, my lord, explained by me, my lord, in following paragraphs 16B. But kindly, my lord, I just read out so that 26B, my lord. A plain reading of the aforesaid norms and standards shows that for every 30 students in a class, there must be one teacher. Unless the number of students exceeds 60, they will not get another teacher before number exceeds 90. And it goes like this until the number of students reaches 150. And only after the number of students goes above 200, then the number of students in each class should be restricted to 40 only. Therefore, there cannot be in one classroom more than 40 students or children. As a natural corollary, in case the number of students exceed 40 in a particular class, say for example class 1, the class has to be divided into two sections, section 1 and section 2, and that will require 2 teachers. It's clear to you, is what I'm trying to say.
Yes.
In a class 30, then my lord, suppose in a particular class 1, I will take your lordships to the other schools. Then that will be your lordships, 2 teachers required, above 40, up to 30, then 40 maximum level. If it exceeds 40, that has happened, your lordships, in school number 1 and 5 in the paragraph 8. I have given your lordships the details of that. Paragraph, I just take your lordship. I have given those details. Kindly come to paragraph 8, small d. That is your lordship, first school number 1, page of the 8.1 of the writ petition. Satyendranath Bose City Free Primary School, Paniati Sati. I could not give the breakup class wise, or kindly see. 8D. Class-wise breakup of the school number 1 mentioned in the paragraph 8 of the writ petition could not be provided by the petitioners with the writ petition. The petitioners have been able to collect the class-wise breakup of the school number 1, which are class PP2, 22 students, PP manner pre-primary. As you also got it, paragraph 8D, page 5. Let me read out again. Class-wise breakup of the school number 1 mentioned in paragraph 8 of the writ petition could not be provided by the petitioners with the writ petition. The petitioners have been able to collect the class-wise breakup of the school number 1, which are classes PP stands for pre-primary, 22 students, class 1 46, class 2 26, class 3 49, class 4 50, class 5 20. Similarly, in the respect of school number 5, class-wise breakup of the students of the said school is class PP 40, class 1 58, class 2 47, class 3 70, class 4 65, class 5 59. Each class, or in a case of 2 sections of a class, each section thereof of the said class is a unit, and each class or section thereof require a teacher, and therefore pupil-teacher ratio must be determined on the basis of each class as a unit, or each class, and not on the basis of the school as a unit. Kindly consider, your lordships, paragraph 131, just your lordships. I have given your lordships total teachers 9. You lordships, kindly consider side by side 131, page 8, paragraph 8, and page 58D of the reply. Kindly see, total teachers 9, head teacher 1.
Yes.
Total students 10, 213. If your loss is divided by 10, what they have done? 3 teachers will be excess. But if your loss is class wise, kindly have a look, your losses. Class 1 requires 2 students under the law. It exceeds 40. Class 3 49, it requires 2 teachers. And then class 450, it requires 2 sections, 2 teachers. So 3 more teachers required. They have declared 3 surplus. Your lordships will get it from annexure in this reply. Kindly come to my lord. This is the list published by the circle wise. Starts at page 20.
No, in paragraph 8 of your reply, this class 146, where from you are getting?
From the school. From the school.
Okay. So in each class, as per the rule, how many students will be there?
Malad, that's Malad, 30 maximum 40. They cannot exceed. Kindly have a look, your losses, to the Right to Education Act. Schedule.
40.
Malad, why I'm saying it, I will deal with when the law, your losses, I will make submissions on this. No. That's why, my lord, we have given 3. We could not given 2, but that's now, my lord, admitted position because they have admitted and the list published your lawsuits will show. My lord, I will take your lawsuits to the law subsequently. These are the facts. And let me, my lord, place it. Now your lawsuits will find page 20 of the reply. It starts from surplus data. Published like this, draft surplus data. This is the basis of the entire implementation of the SOP or like that, or the surplus. Page 20 starts.
Yes.
Kindly, my lord, page 24. Serial number 48. Panihati, circle Panihati. Then your losses name of the school, Satyendranath Bose City Pre-Primary School, Bengali, day school, 213. Kindly your losses,
Yes.
I'm troubling your losses. Kindly abandonment 213 in the writ petition itself. 10 teachers, exactly that. Malad 0, that indicates number of para teacher. There is no. Your losses will get the headings, malad, column wise at page 20. Then your losses 21:1. This is your lordships PTR. What they have done, they have divided 213 by 10. And therefore, according to them, the ratio is 21.1. Absolutely wrong according to me. And then surplus 3 teachers. Then give the name of the surplus teachers they have given. Shubhodip Saha, Debomita Pal, Jhumpa Malakar. Malad date of birth was given. That's malad different arguments. My case is that you have to determine the surplus teachers on the basis of class wise. You have not done it. You have done it school wise wrong. Biology on the basis of redeployment or deployment or transfer on the basis of biological age. That's another point. Transfer or redeployment made on biological. First, if I'm not a surplus teacher, how could you redeploy me? That's my point. Biological argument, that's the second argument I will make. So this is wrong. Kindly see why I am saying again. Kindly take your losses. Any other school of from this, then I can answer your losses from this chart. Any of the school take, for example, for the calculation of deficit teacher or surplus teachers. Now, kindly see 49, for example. We are serial number 48. Kindly see 49. Panihati, Shodhpur Polli Patsala, Bengali, they 8 students, 2 teachers, no para teachers, 4:1. That means they have divided 8 teachers by 8 students by 2 teachers, 4:1, no surplus. But what will happen if your losses, there are 5 classes from this year? Now, even if your losses go by 6 classes, even if your losses go by 5, pre-primary to primary, in these 8 students, suppose one class there is no student, but the other 4 classes students, the class is different. One teacher cannot simultaneously teach students of class 1 and class 4. It cannot. Even there is one student. Right to Education Act protects every student's teaching. You cannot deprive him. That's the act. And that's the constitutional goal. Free and compulsory education up to 8. That's the right of the children and the right of the teacher also.
Yes.
So this is the basis of that. Now again I am taking your lordships to 626B I placed 26C. I have tried to explain it, your lordship, in my own humble way. C at page 137. I have placed before lordship 26B.
C.
In a given situation, where in respect of school number 2 under paragraph 8 above, number of students or children are below 60. Because I could not give 4 and 5, 1 and 5 details of class-wise student strength. That's why I've dealt with 2. But there are students in each and every class from class pre-primary to class 5. But if the admitted number of teachers are taken as 2, then there is no teacher to teach the students for the rest 4 classes. This is inevitable, my lord. Inevitable. Unless your lordship say that divide the teachers amongst the 2 classes. 2 classes will be taken simultaneously. Then entire act will fall. Act says for each class there will be 1 teacher. Act says number of classes, number of hours of the classes. How could it possible? Then your lordships, this exactly happens in school number 2 in paragraph 8 above. But 2 assistant teachers have been treated as surplus. They are not surplus because school need them.
Yes.
Moreover, there is a head teacher in the school contrary to norms. That's different aspect. This is factual, your lordships. Your lordships will find in the other school background, your lordships will get it.
School number 2 is serial number.
Your lordships, school number
2.
Serial number, your lordships, 132 page, para 8, continuation. Madanpur.
No, in affidavit, in reply.
Affidavit, my lord, this, my lord, circle wise, I could not get, but I have a copy probably. I could not annex it because all the documents I have not. That's why Panihati I haven't. If your lordships wants that, I can have a copy. I can hand up with a copy to them also. And they have admitted this, my lord. I have given details. Paragraph says that admitted. And they have not come up with any other figures. Is admitted. I'm down. ওদের একটা কপি দাও ও এটা হাতের লেখা তোদের নিস না ওর হাতের লেখা
Facts have already been implied on which we cannot take instructions because there cannot be any reply to reply. Now, my lord, if these
I am not giving. I am not giving.
Difficult.
I'm not that. I'm not giving. But your lordship, let us. I'm not giving. Let me conclude it. Now, my lord, I have given 2 details. They have not denied it. Admittedly. So let us proceed on admitted. That's why I've given the advance copy. If they say this is not correct, they should have come up. I will show a judgment. The state, no, come up with details. You have failed. I cannot argue, please. Not argue. I have given in the details. At least 3 schools. What is your response to this? Are you denying these facts? You are not denying.
Okay, continue.
1 circle I have given your lordship as an example because 57 circles I cannot annex and I have not got 57 circles. The state should come up that no, Madanpur SSP primary school, this is not the figure, these are the figures. Then I could have understood. Why is that? In the affidavit, you have not denied it. You have done it on the basis of school wise.
Yes.
I have given, that's why in the petition itself.
Yes, continue.
Then your losses 132, your losses, kindly have a look at this. Madanpur. That's my chart I could not give my annex to your losses, I got it subsequently. I can go to this extent. They will have the time, let them cross-verify and tell your losses these are incorrect. Because one I have given Paniyati circle in reply, they could have free to know these are incorrect, what I am saying. Because they have not said in the. So that's similar. If they want, I can give it. This has been done like this on the basis of school-wise. Now, these are the factual background. So for reply they have net. So they could have dealt with it. In respect of 3 schools I have given, kindly have a look. Madanpur SS Free Primary School, Dikpala Free Primary School, Balugachi Free Primary School.
Yes.
Now kindly have a look your lordships, page 132-4. Balugachi Free Primary School, Banipur Circle. Present strength of the student 103. Present strength of assistant teacher 2. Head teacher 1. Here, my lord, 1 have been shown deficit. Kindly see the calculation. My lord, 103. If your losses go by 3, 1 is deficit. Because 1 teacher required, they are doing like this. I have the, my lord, that chart. But since my learned friend taking exception, I am not producing it. They have not said what is the correct situation. Rather, they are saying admitted. All that's there. Now, this is the malad. So, first point relates this factual background. Now, I take your lordships to the provisions of law. Malad, kindly take your lordships the right to education as your copy. Yes. Now, malad, I first make reference to paragraph 19. Sorry, malad, section 19. Section 19, number 1.
Yes.
No school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in the school.
Yes.
Then your lordships, subsection 2. Where a school established before the commencement of this act does not fulfill the norms and standards specified in the schedule, it shall take steps to fulfill such norms and standards as its own expenses within a period of 3 years from the date of such commencement. But here all schools are aided schools, financed by the government. Where a school fails to fulfill the norms and standards within the period specified under subsection 2, the authorities prescribed under subsection 1
Yes.
of section 18 shall withdraw recognition granted to such school in the manner specified under subsection 3 thereof. And then your lordship, penultimate paragraph, section, provision. With effect from the date of withdrawal of recognition, no school shall continue to function. This is section 19. Then your lordships, kindly, section 25. Within 3 years from the date of commencement of this act, the appropriate government and the local authority shall ensure that the pupil-teacher ratio as specified in the schedule is maintained in each school.
Yes, yes.
Malad, I will take your lordships immediately thereafter to the Malad schedule. But before that, Malad, I am placing subsection 2 of section 25. For the purpose of maintaining the pupil-teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school. Malad, rest is or office or deployed from non-educational purpose. This is the disjunctive provision. For non-educational purpose other than specified in section 20, that is different. No teacher posted in a school shall be made to serve in any other school for the purpose of maintaining people teacher. Therefore, my lord, my point will be on the basis of facts. If I am not a surplus under the act, it's a central act, everybody has to abide by this, then you cannot deploy me to serve another school unless your declaration of surplus is good in law. That's why I'm submitting that this goes to the root of the matter. It's not a general transfer. I could not come up before your lawsuits because transfer is an incidence of service. But you are transferring someone or deploying someone on the garb of surplus when your very declaration of surplus is wrongful. Kindly visualize for the purpose of maintaining the pupil-teacher ratio under the subsection 1, no teacher posted in a school shall be made to serve in any other school. Any submission made in regard to this in their dealing with their submissions, I will deal with in my reply that you cannot do it. Why I am saying it, your lordships? Suppose there are 4 teacher surplus in one school according to them, but which is not under the law. Then you cannot do it to compel him to serve another school because this is protected. Well, kindly see 26 also.
25(2) is to be read along with 27 also. 25(2) should be read with
Exactly,
27.
exactly. 27.
27.
Then your losses,
Complete the sentence.
kindly see, no teacher shall be deployed for any non-educational purposes.
Yes.
Other than the decennial population census, disaster relief duties relating to election to the local authority, state parliament as. That's your lordships protected in the 2 also. Subsection 2 of 25.
No, it is not that. Since one is not a surplus, he cannot be transferred. It says that for the purpose of maintaining PTR, again read under subsection 1, that is 24(1) says PTR. No teacher posted in school. Means you are putting a teacher in some non-educational purposes where the PTR is affected. It does not say that since there is a surplus or not deficit, you cannot transfer. It is not that. It is said that the PTR is getting affected for the purpose of non-educational purpose other than 27. That means if you read 25(2) and 27, 27 give the purpose for census suppose. If there is election suppose, you can put that person for such purpose,
no issue.
Affecting PTR. But
no
other
issue.
than 27, if the PTR is affected, you can take steps.
I tell you lordships. Then PTR is affected. Surplus word your lordships will not find in the act. Surplus word. Nowhere in the act. But your lordships, one has to come to that particular expression, either surplus or excess, when your lordship determine the PTR ratio or by the authority. One has to come. Otherwise, how this will be determined? Now, kindly see your lordships. For the purpose of first part, no teacher posted in a school shall be made to serve in another school. That means, suppose, my lord, according to them, in X school, pupil-teacher ratio to be maintained. And that's why Y teacher who is not surplus to be served.
No. You come. No teacher posted in a school shall be made to serve in any other school or office.
Now that's disjunctive.
Or deployed for any non-educational. Suppose a teacher is being transferred to another school for the purpose of non-educational purpose other than 27.
And so far the to serve in another school.
That is what I'm saying.
That's your lordship says this
office,
is not disjunctive. This is
one is
conjunctive.
office or any other school deployed for non educational purpose other than 27. If that purpose affects PTR.
No, my lord, I tell you, losses. When I'm a teacher, whether surplus or not, deficit or not, I'm duty bound to these non-educational purposes as my lord enunciated in section 27.
Correct.
Now, your lordship has to ascribe some meaning to the first part of it. Otherwise, it will be redundant. Suppose your lordship, for the purpose of maintaining pupil-teacher ratio, for maintaining pupil-teacher ratio, one is not deputed for election duty. It is irrespective of that fact. This is my submission. Irrespective of that fact, teacher has to go. What is happening now in census? Teacher has to go. But for that is not the object. Object for the purpose of maintaining pupil-teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school. This is different aspect. What I'm trying to give an example, your lordships. I am in Y school. I am not surplus. Here, my lord, pupil-teacher ratio is not maintained. You cannot take me from this school and post me in and that school. That my submission in regard to first part. And the other part, my lord, I am obliged to do because Act mandates it. This is my submission. Therefore, my lord, the first thing, surplus has to be determined or excess. They are saying, my lord, in their chart also they have saying, my lord, status of the teachers or no surplus teacher they are saying. Lord, kindly see 26 also.
Yes.
Now, kindly see 26 also. This has also some relevancy. Filling up vacancies of teachers. The appointing authority in relation to a school established, owned, controlled, or substantially financed by funds provided directly or indirectly by the appropriate government or by local authority shall ensure that vacancy of teacher in a school under its control shall not exceed 10% of the total sanction strength. Well, the sanction strength is given on the basis of roll strength. Roll strength, 1 year fall, 1 year may increase. But sanction strength remains. So you cannot make vacancy more than 10%. That's why my paragraph here, in reply 8D, I have given how much sanction posts and how much total teacher appointed. I think more than 2,000 teachers appointed without the sanction strength. This is some relevance. Now, your lordships, kindly come to the, I take your lordships to the schedule. Then I will take your lordships to section 8 thereafter. This schedule, my lord, with reference to section 19 and 25.
Oh.
Now, let's kindly see serial number 1, number of teachers. Then I will go to your lordships, the right hand portion, normal stance. Number of teachers for first class to fifth class. Now, kindly visualize, my lord. Legislature do not use any word for redundant purpose. For, my lord, signifies each class, not from. For first class to fifth class. It denotes class with reference to each class. Up to 2025, this was in the West Bengal up to class 4, elementary education, primary. Now from this year, government has done 5th. Therefore, each school has 6 classes. Oh, favare dara na samner bochor last disturb koriস effect এই ইয়ার থেকে হচ্ছে যাই হোক হলো এক বছরের তো 6 classes. Now for classes first class to fifth class, form signifies or refers to the class, not the school.
Just a minute. Yes.
Then your lordships, admitted children up to 60, number of teachers 2. What they do, my lord, if the total strength is 60, they say you will get 2. But there is already a 4th teacher. I have seen, my lord, serial number 2, because there are 6 classes. Then what happened to the others? You cannot give a meaning, my lord, which is not, which takes us to the absurdity. There cannot be a class idle. So this has been dealt with appropriately by the judgment. I'll show to your losses that. Then your losses kindly see. My lord, building under schedule, my lord, number 2, building schedule itself. All weather building consisting of, number 1, at least 1 classroom for every teacher and 1 office cum store cum head teacher's room. My lord, entire schedule has to be read together. What does it say? At least 1 classroom for every teacher. This again signifies that there must be 1 teacher for every class, not for the school. Please. এই রানিং কমেন্ট গুলো বন্ধ কর, আমার অসুবিধা হচ্ছে, আর ও তো পলিটিক্যাল উত্তেজিত হয়ে যায়। At least 1 classroom for every teacher.
Yes.
Then I will take your lordships. Kindly consider paragraph, section, my lord, 8. I placed it, my lord, my lord, take your lordships to refresh your lordship memory. This I have taken. 8D. My lord, this is mandatory duty. Expression
8D
says
of?
TAL.
8D of?
8D of the Act, Right to Education Act. Provide infrastructure, including school building, teaching staff, and learning equipment.
Yes.
So, my lord, if we read what I read, my lord, according to me, because my reading, your lordship, class-wise, they are school-wise. My lord, teaching staff means class-wise you have to provide. Unless you maintain this, you cannot go to the next provisions of the Act for redeployment, because you have not able to provide the basic structure, infrastructure. Infrastructure includes teaching staff, classroom. But there is a pleading. Well, there are not sufficient classroom in so many schools.
Yes.
And this, your lordships, this is the, my lord, appropriate government, duties of the appropriate government. Your lordship will find the similar duties under section 9D, just your lordships, section 9F of the local authority. Well, the council, each primary council, school council is a local authority. I think, well, this will not require any argument unless they say it, they dispute it. That council is a local authority. Well, local authority has been defined. Your losses will find in the Act. Local authority, your losses will find 2H of the Act means municipal corporation, municipal council, Jela Parishad, Nagar Panchayat, Panchayat, by whatever name called, and includes such other authority or body having administrative control over the school or empowered by or under any law for the time being enforced to function as local authority in any city, town or village. So for the council, my lord, is constituted under the West Bengal Primary Education Act 1973, and it administers, runs, manages all primary schools throughout the district, and each primary school in each district. Therefore, my lord, this is a local authority. Now, your lordships, I take your lordships to Rule 2002. I have annexed of the transfer rules. Yes. Page 168 of the writ petition. Maybe come back, my lord, after 2.
দুটোর সময় কি আছে? আড়াইটের সময়।
My lord, I am susceptible to any direction to continue of your losses to continue this, subject to your losses convenience.
তাহলে ইয়েটা হবে না ছিল? এটা দিলে হবে না।
আমি তৈরি হয়ে এসেছি, আমি কাজ করবো। যদি জোসেফ পারমিট করেন আমি করব।
30
My lord,
230
মাত্র ওকে এই পয়েন্ট আমি আর বুঝতে এই পয়েন্টটা তো
Lord, may I only take back my copy of
Oh,
AO
sorry.
so that, Lord, I can make a fresh copy for my Lord.
এটা কম্পোজ পেপার
আমাদের এফিডেভিটটা বার করে রাখুন। আমাদের এফিডেভিটটা বার
থেকে দুবার
যেটা ফাইট করেছে তাহলেই হবে।
My lord, we have prepared an appeal, my lord, it dismissed on 28th, last Friday. My lord.
Dismissed.
On the
Where is the
limitation
compliance
point, it is dismissed, my lord.
The order may be complied with.
Order complied.
My lord, order has not been complied with, my lord, as it is dismissed on last Friday, my lord. And thereafter, my lord, from today, my lord, only working days start from today, my lord, thereafter, after dismissal, my lord. The authority started the process, my lord, it will be complied with, my lord. With instruction, I am submitting, my lord. Allow me only 2 weeks time.
Mr.
It may be next Thursday, my lord. It may be complied next Thursday.
You are for?
No, sir, the next Thursday it may be complied with.
My lord, what happened, my lord? There is 2 holidays, my lord. I need Wednesday is the Friday, my lord, holiday, my lord, and also Friday is the also Friday holiday for the state, my lord.
We give it.
I am
Mr. Falguni,
praying for another 1 week, my lord.
for the alleged contemner number 1.
Only 2 weeks time, my lord.
The appeal which was preferred against the order dated 6th August 2026 passed in WPA 11718 of 2024. Appeal no within bracket when being 130 mat 1301 of 2026 has been dismissed on 21st August 2026. He seeks some accommodation. He submits that the order of this court will be complied in the due course. He seeks some accommodation, short accommodation. Is this matter on Monday week or din to?
My lord, Friday week, I am praying for only Friday week, my lord.
By আমরা কত তারিখে আছি?
My lord, humbly praying, my lord, it is only on 10th.
On 7th September.
My lord. If it is 10th, my lord, I humbly praying, my lord, only 10th.
On 7th September. This week, then next week is also there. 2 week time has been.
I'm grateful.
It will be order. The theory. Are it is a matter to us. The 30 matter to Ashwini on the other side. State has not come. আমাদের এখান থেকে কিছু ডেকে দাও তারপরে State is there.
Okay, my lord, Mr. Loknath, please come.
Mr. Chaturvedi has come.
This matter is continued for some time.
2 PM matter is
That is why others matter may not be.
I will take your lordship busy up to 4 p.m.
But then others matter may be released for the day. Otherwise,
4:30 চলে যাবে কেন?
Oh, 4:30.
Some matter can be.
তুমি 4টা মানে 4:30 চালাবে
না চালাবে।
So far the 2 PM first matter is concerned. But I am only seeking that cannot be decided on motion stage matter. Given a direction.
ওটা তো টপিক আছে তো টপে আছে তো নেক্সট মানডে তে টপিক রাখো করোনা দেশ সাইড না করে কি করে করব মিস্টার ভট্টাচার্য অন নেক্সট মানডে আই উইল টেক ইট আপ আদার সাইড ইজ নট
category matter will be taken up on next Monday. Because I have the second and third matter, that is why I am paying.
All will be as it is. It will be posted on Monday.
Next Monday. That's too much. No other matters for the day.
বললেন তো কতবার বললেন
সেটা জিজ্ঞাসা জেনে নিলাম পারে
তুমি তো বলছি আবার কি বলছো
তো বললো 4টে পর্যন্ত তারপরে
এসছে লোকনাথ না আরে ঠাকুর ভাই আমি বলবো শুনবে কি নোট নেবে তুমি নোট নেবে তো
নোট নিচ্ছি স্যার আপনি
লোকটা নিয়ে আছে মিস্টার চতুর্বেদী জুনিয়র আছে মিস্টার চতুর্বেদী জুনিয়র ইজ দেয়ার You are Mr. Banerjee's junior. You got take me.
And so far, Mr. Chaturvedi, Chatterjee ko, Mukherjee? ঠিক আছে লোক
না উনি করছিলেন কোথায় গেল ওই ওপরটা হ্যাঁ 19893 এইখান থেকে না আর এই শিট দেবেন না, এইখানে থাকছে, এখান থেকে টেনে বার করবো ফাইনাল যখন হয়ে যাবে। স্পাইরাল বাইন্ডিংটা করে দিয়েছি, কেটে নিয়ে ফ্লিপ করে দিয়ে দেবেন। সুবিধা হয়েছে না? You have referred to section 8D and 9F, this infrastructure.
And so far Act is concerned, Act means Right to Education Act, not I have placed the provisions. What I will develop argument, my lord, I will just, so this is the point regard to declaration or identification or determination of surplus teachers. So I have stated, my lord, as I find from the documents from myself and the governments too, but governments of the state are not at all clear what they're doing. I will go to that extent. The state cannot shirk its liability to disclose the facts before the court. I will show that. What they have said, your lordships, I have submitted, your lordships, the words or expressions surplus, your lordships will never get it in the Act, Central Act. This has been dealt with, my lord, in the other judgments. Now, I will take your lordships to some of the paragraphs, how they have dealt with this, or what they have stated in reference to that in other
Devanath Babu,
paragraphs. Then I will take to the other
item number
provisions
1
of
এর
the.
affidavit in opposition টা বার করুন, item number 1 এর।
জোসেফের কপি নেই এটা?
Item number 1 এ আছে ওটা।
না না আছে, দিল তো ওরা, ওটা এই মাতাল তো
এইটাই
ওই
opposition আছে। এইটা। No, I have got it. In item number 1, they have filed it. I have got it.
মার্কিং
এটা খুলে
করতে
দিন।
প্রবলেম হয়ে যাবে।
দিন। ব্যাস। Yes.
No, my lord, as I submitted, we will see the affidavit is not clear, but in reference to paragraph 7, 8, as I placed before your lordship, they have admitted facts. In respect of, my lord, the class-wise teacher, in respect of 3 schools, they have admitted. They could have produced the documents. My lord, it's a basic principle of pleading, my lord, as we have learned from this college life. So for the statements in the pleading made, they can first deny. Then if I have a specific case in my pleading, you have to place your specific case denying that with the particulars. That was not at all done. And that's why on the contrary, they admitted. Now, in reference to that, this point, what they have stated in the other paragraphs, I just take your lordships for your lordships convenience, because ultimately this ground this point I'm developing. If your lordships kindly take up their affidavit, some of the paragraphs I will just show to your lordships.
Mr. Chaturvedi, the other writ petitions, the affidavits are ready, which you
common affidavit copies
you submitted in the morning session that you'll be submitting separate affidavits in.
Yes, my lord, the copy, my lord, in
the copy this.
Yes, my lord, the copy which I took back, my lord, I am giving supplying
No,
fresh
not
copy.
this. In the in respect of the other writ petitions, you are filing any affidavit in
No
opposition?
fresh affidavit.
Same
affidavit, my lord, relied upon. I am not giving this copy to my lord because it was my marked copy, my lord. I am supplying a copy.
Now I have got that.
Oh, I'm so sorry. তাহলে এটা অন্য আরেকটাতে তাহলে কাজে যদি লাগে তাহলে লাগবে।
Yes, Mr.
Paragraph 3, page 3, paragraph 4. What they have said in response to the other paragraphs. If your lordships.
Page 3, paragraph 4 of
4. Affidavit in opposition. I'm trying to what they have stated in their affidavit in regard to surplus. How the surplus is determined.
3, paragraph 4. Yes.
It is submitted at the very outset and as a matter of going to the root of the controversy. That's really true. The exercise impugned in the connected writ petition is not in substance an exercise for transfer of teacher simplicity, but a process of rationalization of the deployment of teachers undertaking in consonance with Section 25 of the Right of Children to Free and Compulsory Education Act, which enjoins that the appropriate government and local authority to maintain pupil-teacher ratio prescribed in the schedule to the said act by inter alia redeploying teachers found to be in excess. That's I'm submitted, Malad, surplus or excess. Excess in one school to another school, where the prescribed ratio is not maintained. The Malad, excess, how to be determined? That's the point. With reference to the school or with reference to the class unit of the each school. Malad, they have not said, Malad, anywhere what has been done, because my at least 4 or 5 paragraphs I have dealt with in the writ petition. Forget, Malad, about my reply. This is the first thing. I will also show your lordships the redeployment is also a transfer. If an employee placed from one place to another place is a transfer. I will show that, your lordships. Transfer of an individual teacher, therefore, Malad first says redeployment, then ultimately admits that this is a transfer. Individual, wherever it becomes necessary in the course of such rationalization. Malad, what meaning would be given to this expression rationalization? If one school is teacher is in excess and another is in shortage, then from that school to this school. So this has to be determined. How? That's my point again.
Yes.
Then you'll also page 6, paragraph 8. With a view to rationalizing the deployment of teaching staff in government-sponsored aided primary school across the state and to identify surplus teachers. So they say this is surplus. Posted in zero enrollment schools so as to redeployment them in schools genuinely in the need of teachers. Malad, for clarity, I'm again, Malad, submitting for zero enrollment school. I have no issue, Malad. So far, I am concerned in the present writ petition. That has to be transferred. But on the basis of surplus to be determined. Kindly see there are 2 parts of it. They say deployment of teaching staff across the state and to identify surplus teacher posted in zero. Malad, surplus teacher only not Malad, transferred from one school to other. Then, Malad, consistently with the mandate of maintaining prescribed pupil-teacher ratio under Section 25. That's my case, that this is not done under Section 25. Then your lordships kindly consider, Malad, the same page, Malad, the last line of paragraph 9. Malad, kindly, I will place immediately this clause. Clause Roman 7D of the SOP. So as communicated on 11 July 2006. Provided for identification of the teacher to be treated as...
you are reading from?
Page 6, paragraph 9, last line of the affidavit in opposition.
Yes.
The clause 7D of the SOP as so communicated on 11 July 2026 provided for identification of the teacher to be treated as surplus on the criterion of seniority by the date of joining, subject to the option willing. I pause here for a moment. Kindly think over it. Whatever the SOP they follow, that's different issue. There are 2 methods: initially joining of teacher and another biological age. Neither of the 2 concept referable or relatable to the declaration of surplus teacher, but they say should. Then what stand I will take? Clear to your losses. Surplus to be determined with reference to pupil-teacher ratio. This cannot be determined by the joining date of the teachers. Joining date of the teachers necessary for redeployment or transfer, not for declaration of or identification of surplus of teacher. Then what's the stand of the state? Then your lordships, kindly consider page 11, paragraph 15. I'm placing it, I'm troubling your lordships. Kindly see what case they have made out. My case may fall, may win, my lord. But I have case made out that it has to be with reference to classes of the school. Paragraph 15, main issue under the heading. The principal issue, rightly, my lord, this is my main issue, arising for consideration in the connected writ petition whether memo number such and such dated 10th July 2026 and SOP framed thereunder. My lord, I request your lordships, kindly see this language. I will take your lordships repeatedly in respect of my second point, which I have not yet urged. The SOP framed under this memo. They have repeatedly said it. SOP framed by this memo.
Okay.
For identification and rationalization of deployment of teaching staff and the transfer of surplus teacher from zero enrollment school. My lord, I request your lordships, I will place it to consider none of the SOP, my lord, refer to or prescribe any modus operandi for identification. It only refers to the Act of 2009, Right to Education Act, for identification. Never. None of the SOP prescribes that these are the methods to be followed for identification of surplus teacher or excess teacher. They only refer to a T Act. So what does it mean then, your lordships? Then, you know, in particular, biological age criterion under clause 7, D and F. Lord, I'm really perplexed. What is this affidavit? Is it with reference to school? Is it with reference to class? Or is it with reference to biological age the surplus is declared? Which method? State must come forward a stand. I have taken a stand that it should be under the Act of 2009. It conceives only class-wise surplus teacher, and if the class-wise found that teachers are excess, they are supposed to have 5 classes, teachers are 7, then surplus, not by the total roll strength of the school. I am repeatedly harping this, and this is my case in the writ petition. So this is the main issue they have dealt with. I will take your lordships to the SOP. Then your lordships, paragraphs, I have placed 16.3, factually admitted. Malad, they have, I have seen, Malad, in some of the where they have said, this is a composite affidavit, they have said ground number 2 and 4 are dealing with this situation. What we are saying, Malad, class-wise. 2 and 5, I'm sorry, Malad, kindly, 2 and 5. I'm taking your lordships to the ground number, Malad, but any event, Malad, I'm taking the ground number 1. They have said it in affidavit, but I place what they have placed to your lordships.
Page number?
Page number 32. Hey, the repetition number to go to 198 times. Well, kindly see the ground number 1 deals with the 3 repetitions, but it doesn't deal with myself, my repetition. But anyhow, it's a composite affidavit. I rely upon this and take their stand. But I place it to your lordships. The memo number such and such dated 10th July 2026 and SOP framed thereunder. Kindly see, my lord, because this is the source of the SOP, this memo. Everywhere this has been said. Are administrative and executive instructions issued in aid of and for effective implementation of the statutory mandate under section 25 read with schedule such and such. Before going further, this is my submission, your lordships. The provisions of the 2009 Act is a very comprehensive provision. It says how the ratio to be determined and the deployment, if any, to be made. Deployment is one line is there, but not so many. So SOP cannot do with that, and SOP has not done with that. Kindly see then. More particularly, of the power of transfer already expressly vested in Council under Rule 4 of the Rule 2. I will take your losses to the legal provisions. They say this is under the rules. Who will do it under the rules, if any? The SOP, that I will take subsequently. Kindly see, my lord. It is submitted under Rule 4 of the said rule expressly empowers a council to transfer an approved teacher within its jurisdiction on its own motion without any application from the teacher concerned. I admit this power. Without any, and the further proviso to Rule 4A expressly empowers. My lord, this I think they have not considered. Further proviso to Rule 4A, my lord, I will take to this. When I place the roll, my lord, kindly, my lord, after placing the rule, I will make that submission. Now, your lordships, kindly come to, my lord, the last 6 lines of this paragraph. The very concept of a surplus teacher identified by roll strength / enrollment and of rational adjustment of such a teacher to a deficit school. So this is the stand to be taken then by the roll strength. Now point comes up, my lord, roll strength relatable to the school or to the class. If it is the school situation, my lord, what they have prepared, chart, I have given to the reply in respect of Panihati circle. But if it is class, absolutely wrong. So, my lord, affidavit your lordships is not formed with clarity. The what is the state is doing, I have a right to know. Even I have punished, I have a right to know how I am going to be punished and what is the punishment giving to me. Whatever, my lord, but this is the right of the citizen, protected right under the Constitution. But this is the taken which lie at the heart of the impugned memo. So this has to be accepted by the Honorable Court. This line, roll strength. This is the only, this has been done on the roll strength. But what are the materials before the court as we disclosed, admitted by them? This has been done with the roll strength of the school, not to the class. Then your lordships kindly see paragraph 2. Ground number 2. Reply. My lord, here, my lord, my writ petition has been referred to 19893. That's why I'm saying, my lord, ground 2 and 5 deals with my whatever submissions made in these 2, they have stated in their affidavit. The identification of surplus teachers necessarily requires an objective, uniform, verifiable yardstick capable being applied simultaneously across thousands of schools without scope for subjective discretion or favoritism. It is submitted that while the further proviso to Rule 4 of the 2003 expressly empowers the council to transfer a surplus teacher identified by roll strength on its own motion by way of rational adjustment, the said rules are silent as to specific criteria. My submission is absolutely erroneous submission because Central Act specifies how it is to be done. State Act cannot do it and state has not done it. How? Your lordships kindly keep in your lordship memory that referring to proviso, further proviso to Rule 4. That's their saying. I will take your lordships to that immediately, my lord, after this placing these paragraphs.
Yes.
So rules are silent so as to the specific criterion to be applied for selecting which teacher? Amongst two or more similarly circumstanced teacher in the same school. Well, I fail to understand similarly circumstanced, what they are trying to say. Give an example. Then I could have given it in reference to my school. I have given the details. It's not clear. In reference to which two circumstances? Act says what is to be done. Central Act. Then your lawsuits will, this has been so far done, and then your lawsuits, ground number 5 at page 36. These are all, my lord, I find pleadings. Whatever by way of submissions, fair admission, my lord, or statement. Kindly see, my lord, reply. Here also refer my petition 19893.
Yes.
The methodology for computation of the pupil-teacher ratio and identification of surplus teacher is a matter of academic and administrative policy. Lord, I say is absolutely wrong. Central Act specified how this is to be done. And this is, my lord, the unconstitutionality, if they say so. Absolutely wrong, my lord. They cannot go beyond the RT Act. Within the domain of the department, formulated keeping in view the distinct statutory rule of the head teachers, all that. That's different, my lord. Head teacher I will deal with separately, my lord. So, my lord, these are the abhorrments. I just request your lordships kindly keep, my lord, my abhorrments 26B, apart from 7 and 8, 26B to GH. I have elaborately dealt with reference to 5, my lord, schools. Yes. Now I take your lordships to the SOP itself. Lord, kindly will look at your lordships, my lord, consider page 164 of the writ petition. My lord, kindly, my lord, at the motion stage, I placed it before your lordships. Kindly consider scope, Roman 3. Scope means it applied to all governments aided schools. Page 164.
Yes.
My lord, scope, Roman 3. Surplus teachers identified in school where staffing exceeds the prescribed norms of RT Act. That's why I'm repeatedly submitting, my lord. This does not, my lord, prescribe any modus operandi. It cannot, because the Central Act prescribed it. They say only that I will do it as per the Act. And then your lordships, paragraph under the heading procedure, your lordships, I will take your lordships. Roman 3, identification of school with surplus teachers. Roman 4, identification of surplus teachers. This doesn't refer to any provision. This has to be read with scope Roman 3. Otherwise, you can't have it, do it. This has to be read with the first Roman 3 under the heading scope. And then your lordships, kindly see, the district authority, 5, identification of school with high PTR. These are the broad line, but how this is to be done, that the Central Act says. And that's why you says in accordance with the norms of the RT Act. Then Roman 6. District authority within district inspector of schools, AC, we are not concerned. Then DPSC, that means councils. Primary school council for the primary school shall publish a list of school having teacher shortage high PTR indicating school name, district, block, surname, category of teachers required including the subject in case of secondary or higher secondary schools. I'm going to pause here for a moment. This is their SOP. The council has to determine it. Council will have done it according to a circle wise. I have given one. I restricted myself from not giving to your lordships others because I could not disclose it, even my reply. They are saying that how could I deal with it? My point is, you are the state. You are the model employer. You should have come up with these. These are my list published. Where are those lists published? Malad, these are published. I have stated in the affidavit. Malad, these are not published. These are published in a sense. Malad, in all circle, there is a WhatsApp group between the sub-inspector of schools and the headmasters of all the schools. I do not, Malad, join this issue with that. This is proper nowadays. We are now in a Malad electronic age, so this has to be for the administrative. This we have got it from that method. We have stated in our reply. But you have disclosed it. Why have you not disclosed it? What is your papers? The list? You should have come up that I have done it like this and this is lawful. Then we could have dealt with it. That's why we have disclosed it and you are admitting. In the petition paragraph 8, you are admitting. Natural, ঠিক আছে.
Yes.
Now, then your losses kindly see Roman 7. They have referred to D. Kindly see. Identification of staff for transfer. Well, I just pause here for a moment, I request. What is the heading? Then clauses. Identification for staff of transfer. Well, when this comes into operation? After identification of surplus teachers. Those surplus teachers to be transferred. I'm clear to you what I'm trying to point out. Before that, identification of surplus teacher. This comes in after identification and the list published. So identification of surplus teacher or identification of staff for transfer are two different methods. In their affidavit, they are not clear what they are doing, what they are mixing it up. I have placed your lordship, I may be poor in understanding English language. But what do you say? You say by biological age, by joining of the teachers in one SOP. Kindly see now what says your lordship, but according to me, that will be clear. All non-teaching and non-teaching staff posted in zero enrollment schools shall be considered for transfer. I have no issue. So far, primary school, your lordship, one factual thing, there is no non-teaching staff. No non-teaching staff at all in primary schools. All are teaching staff. Then teachers who are already placed on deployment may be transferred to the placed school if required as per PTR. But I do not. Surplus teacher from other schools shall also be identified. Then, for consideration of the surplus teachers, senior teachers in respect of the date of joining shall be considered first for transfer. Because under the heading you are transferred. It is pertinent to mention that there is no such provision in the existing rules. This has been purportedly or allegedly, this part, your lordships, modified. That another submission will be, your lordships will find it, the same provision at page 66, except D. Kindly see, this is also Roman 7, identification of staff for transfer. Then, for determination of the surplus of a teacher of a school, teachers younger in bar shall be considered for. So, determination, surplus has been done under the RT, it has to be done under the norms and standards of the RT Act, and those surplus teachers are to be transferred under what criteria? That's another issue. Joining or biological. That's the another limb of argument. That's so. This is not the age, biological age or joining date cannot be a criterion for determination of the surplus teacher.
Yes.
No, your losses, I take your losses to page 168. Now the rules, I'm again coming to the provisions of law. I placed RT Act 2009, now your lawsuits. My lord, this is rules, transfer rules of teachers of 2002. My lord, these rules, when framed, my lord, RT Act didn't come into force. RT Act 2009. Now, my lord, kindly see rule 3, role strength of a teacher. Role strength of a teacher. My lord, this very expression indicates that role strength is referable to the teacher. Primary school under the jurisdiction of the council ordinarily shall have one teacher for every 40 pupils or part thereof, not being less than 20 in a hilly or forested or other thinly populated area. A second teacher may be admissible when the roll strength exceeds 60, and the third teacher may be admissible when the roll strength exceeds 100. Similarly, a fourth teacher may be admissible when the roll strength exceeds 140 or so on. But in no case a primary school is to have less than 2 teachers. But my first submission, whatever interpretation we give to this, or the Honorable Court gives it to it, this should not be considered right now because of the RT Act, Section 25 and the schedule thereof. Everything has to be done under that. So for determination of ratio and surplus teacher or excess teacher. Okay. This cannot have any reference. Then your lawsuits. 4, condition, because that's the central act. My lord, education under the concurrent list, state can always frame rules. When the rules comes up, my lord, the central act will prevail. My lord, 4, condition for transfer. Council may on its own motion or B, on an application from a teacher, transfer approved teacher within its jurisdiction from one council to another primary school on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service, both in case of mutual or single transfer. Then, provided that the council may, if it considered necessary, for proper utilization of service of a primary teacher in the interest of education, transfer an approved teacher without maintaining any time limit of service. Then, proviso further. They are probably embanking on it also with the clause A on its own motion. Provided further where there is a surplus teacher, according to roll strength as stated in Rule 3, the council may on its own motion transfer such approved teacher without maintaining any time limit of service by a rational adjustment of a teacher in a primary school having deficient teacher in the following order of preference: a primary school without an approved teacher, a primary school having single teacher, or other primary school having shortage of teacher. This provision, my first submission, after the coming into force of the Right to Education Act, has become redundant and non-est in the eye of law, because neither the local authority nor the appropriate government can say now that there is the school without the approved teacher. They can't. Kindly visualize the provisions of the Act. They can't say. This was before the Right to Education Act, 2009, and the introduction of the Article 21A, giving free and compulsory education to. But this very provision goes contrary to the Act of 2009. No citation is required, my lord. State cannot say, is there, that's one thing, but state cannot say, where there are without teacher, having a single teacher. You have to maintain always. You have to maintain, except in a sequence, my lord, which happens in the midst of the session. That's different aspect. And that's why you have to keep a pool of teachers. That's one judgment deals with it, my lord. Now, therefore, my lord, these are the provisions they are banking upon. What the state did, my lord, kindly see, after the Right to Education Act come into force. Kindly consider, my lord, page 172 of the writ petition. Lord, I will request unamended Rule 3 and amended Rule 3 read together, my lord. This is 2001 amendment come up. Kindly see amendments. Rule 3, role strength of teacher. Each school shall maintain the required number of teachers in each school as per the provision specified in the Schedule of the Right of Children to Free Compulsory Act 2009. Though belatedly, but the state amended, molded it rightly. Because Central Act, kindly see it goes. Even it was amendment was not there, my submission, so far my little knowledge, it automatically goes. Say after coming into force of the Central Act. But they have done it after 12 years. That's okay. So kindly see what has to done. Only the Central Act. Whatever is there.
Yes.
Then kindly see, then each school shall maintain the required number of teachers in each school. According to me, if I read like this, and whatever I have been submitting before lawsuits, it is class-wise. Then your lawsuits, kindly see. For clause B of role full, just immediately there, substitute the following clause. What was in the clause B? On an application of for a teacher from such and such, such and such, such and such. Kindly see. So clause B also goes. Now the point which I am raising your lawsuits, the proviso also goes. Proviso, the second proviso further, that also goes. Proviso attached to the rule. Rule B, attached to rule B.
Yes.
According to my submission, that goes. Now, even if your lawsuit, any contrary submission made, even that goes, because rule 3 has been amended by inserting or substituting new rule, which says only under the Act 2009. But this proviso goes against the 2009 Act because says in order of preference, primary school without an approved teacher. You can't do it. And I'm clear to what alternative submissions I'm making, my lord. A primary school without an approved teacher, a primary school having a single teacher, another primary school having shortage of teacher. This is a very sorry state of affairs that we are having schools with zero enrollment. Judgment is there, school cannot, recognition cannot be withdrawn by the government for shortage of students. To that extent, judgment is there. Because so far primary schools are concerned. But I'm not dilating on that very much. But these three clauses are contrary to Right to Education Act. And that's why, my lord, the entire thing has been substituted by way of amendment. So entire affidavit, my lord, is based on this. Proviso, further proviso. Whatever power you have, Central Act gives you. No requirement is necessary.
Yes.
Central Act's given the huge power to the school authorities that you can do it like this, giving the entire modalities. Now these are them, my lord. So for transfer. And another thing I take your lordships to that. This appointment appointment rules 16. Probably your lordships have having a book, the spiral binding.
Yes.
2016 rules. I have made a reference in paragraph 17 onwards on that in my read petition. Because transfer your lordship subsequent to the appointment. Before appointment, there cannot be any transfer or redeployment. So how the transfer to be made? This has been conceived by the recruitment rules itself. Paragraph 7. 17 page on the spiral binding. Joseph, I have quoted.
It is there.
Paragraph.
Which page number? Page number?
Spiral binding.
Yeah.
Today I have not got it. That's it. Just. Joseph ke dewa je primary nahi bolo board er kore to dewa ache. আর নেই, এটা তো এইটাই প্লেস করবো, কোড করেছে ওই জন্য। I have quoted it extensively, so far my learned friend can deal with it. Please বলো। No, that. My lord, it starts from page 127 of the spiral binding.
Yes.
My lord, rule 3.1. The role strength of a teacher, for a teacher, of a, my lord, always all words are, my lord, according to me, very important. For a teacher, role strength for a teacher of a primary school, under the jurisdiction of the council, shall be determined as per the schedule annexed to the Right to Education Act. Nothing can be done, my lord, without that. All the rules contrary to this goes, automatically goes. If they say they will follow, provide, suppose your lordship holds it, that proviso, further proviso still remains, that becomes contrary to this act. Because act says you cannot keep a school without teacher after the act coming into force. Section, my lord, 19.2.
Yes.
So what they are saying, this rules, my lord, is a permanent procedure, becomes a permanent procedure. My lord, I can understand at best that immediately after coming into the force, this was the situation, what can I do? But this is not that. Act has come into the 15th year before. You cannot take that advantage right now. If there is any flaws, that's your fault. You have to rectify first before undertaking this job. Without going to the infrastructure, you cannot do that. My lord, teachers are not slaves. I am duty bound to do work. If I do not, you take appropriate disciplinary action against me. But I am not slaves. What will be the consequences? I will show your losses after placing 2-3 judgments. That how the teachers are to be treated now.
Yes.
So these are the, my lord, legal provisions, so far I am concerned, with the SOP also. My lord, I am showing right now, my lord, on this point one judgment, because I have to finish this point, then I will take your losses to the next point. And trying, my lord, to be concise. দুটো গল্প কর্তব্যের না দেখে আমি দেবো আর ওদের খুব ভালো করে বোঝানোর জন্য দাও ওদের দাও ওদের কি একটা দিই মালট দিস ইজ আরে কি আছে তোকে তো খোঁচকানো দিলাম কিছু যাবে আসবে না মালট 2016 SCC online Kerala 29995 matlab, as far as I am in this field for so long, this field of education, I find real losses. So far education matter goes up to the Supreme Court. Not always, this has not gone up to the Supreme Court. First cases comes up always from Kerala, then Tamil Nadu, and then Bengal. Bengal should have been in the first position, now it has become third position. According to my assessment, my lord. Kerala always first. So for education, this would they make. Or BEd একটাতে হবে না generally. But I am taking this. This is deals with RT Act itself. But I will place is very not longest judgment. I will place in its entirety. এই কি রে উল্টো দিকে পিন মারা জাস্ট
এটা না আমারটা না
না তুই দেখ হ্যাঁ বলে may I read it? Well, this is the division bench judgment of the Ernakulam bench of the Kerala High Court. These appeals are filed by the state of Kerala and the official respondents in the writ petition challenging judgment of the learned single judge in WP number such and such, which are disposed of by a common judgment dated 17 December 2015. In these appeals, we heard the learned Advocate General for the appellants and also the respective counsel appearing for the writ petitioners who have arrayed as respondents. Then, your lordships, although various issues are raised and decided by the learned single judge, the only contention that was raised before us was concerning the correctness of the finding of the learned single judge with regard to pupil-teacher ratio, PTR, as per provided in GO number such and such. My dear lordships will find this PTR expression short in the chart I have given in respect of Panihati circle in my reply. Paragraph 4. Before the learned single judge, while the writ petitioner's respondent herein contended that the pupil-teacher ratio as provided in the Right to Education and Free and Compulsory 2009 is to be taken class-wise, the state contended that the ratio is to be maintained on a school basis, directly at the point I am urging before lawsuits. Considering the issue at length, and the learned single judge held that the pupil-teacher ratio should be taken class-wise and not school-wise as contended by the state. The above finding of the learned single judge was impugned by the learned Advocate General by relying upon the provisions of the RT Act. He also relied on the judgment of the Apex Court in Environmental and Consumer Protection Foundation versus Delhi Administration 2011-13 SCC paragraph page 16 and the division bench judgment of the Punjab and Haryana High Court. These contentions are refuted by the learned counsel appearing for the writ petitioners and respondents. We have considered the submissions made. The issue as to whether the pupil-teacher ratio is to be applied with the school as a unit, as contended by the appellants, that means state, my lord, or with the class as the unit, as contended by the respondents, is to be decided in the light of the provisions contained in the RT Act itself. Section 19 of the RT Act provides the norms and standards for the school. Subsection 1, section 18 of the Act. Subsection 1 provides that no school shall be established or recognized under Section 18 of the Act unless the school fulfills the norms and standards specified in the schedule to the Act. Section 25 of the Act provides for tuition preparation as per Section 25, subsection 1. Within the 3 years from the date of commencement of the Act, the appropriate government and the local authority shall ensure that the pupil-teacher ratio as specified in this schedule is maintained in each school. The schedule to the Act containing the norms and standards of in a school is extracted below. Well, the entire schedule has been quoted. Then your losses kindly consider. Paragraph 7. A perusal of the schedule shows, as per clause A, norms and standards have been prescribed for the first class to fifth class. It is to be noticed that the legislature has specifically prescribed the norms and standards for first class to fifth class and not from the first class to fifth class. That's the difference, your lordships. Secondly, this itself indicates that legislature has adopted class as the unit for application and satisfaction of the norms and standards. Turning to the norms and standards prescribed for the first class to fifth class, it can also be seen that in a class where the strength of admitted children is up to 60, in a class, my lord, I'll be a little slow because if we miss any word, my lord, that will lead to, my lord, misreading of the judgment. The number of teachers required is to be 2. Similarly, when the strength is between 60 to 90, it is 3. But everything is read by this honorable division bench with reference to the class. Obviously, the norms prescribed for the admitted children in a class and not in a school, as contended by the learned Advocate General for the appellants. This is all the more clear from the further prescription, clause B, where norms and standards have been prescribed for 6th class to 8th class. Well, that's higher standard, upper primary. The entire thing has been considered by the division bench, the object of the Act. It is also evident that the further prescription in clause 2, where it is also provided that at least one classroom shall be provided for every teacher. It is a hidden, Malad, kindly see, Malad, this very nicely said, paragraph 8. There is a hidden danger in the argument of the state that the school should be adopted as the unit. if the total strength of the students from first class to sixth class is between 60 and 90, it will be possible for the government to run the school with 3 teachers. According to us, that will run counter to the object and purpose of the RT Act, particularly in the light of the constitutional obligation undertaken by the state in discharge of which the Act was enacted. Not as I submitted before, after 21A was introduced in the Constitution as a fundamental right up to class 8, free and compulsory education, this Act came into force to, my lord, enforce the obligation of the state under the fundamental right. That apart, in a situation, kindly similar, it would not be possible to satisfy the minimum number of working days and instructional hours prescribed in clause 3 to the schedule. I have not taken to the schedule to your lordships 3, but I have submitted that it will run, my lord, havoc. If there is 2 teachers, 6 classes, how the student will get the minimum number of classes? It can't. The problem lies, my lord, shortage of total teachers, not the deployment. They are making the teachers as a tool, as slave. You have to be crucified because of the fault of the state. Because I cannot appoint the teachers, you go from here and there. I will show to your lordships that some teachers have to be redeployed every year. Is it the object of the Act, my lord? If this proposition of the state is to be followed, every year a teacher has to be redeployed. They have the family, they have their children, they have the right to lead a normal life. How? You cannot every year do this. Your problem immediately in a war-like situation, recruit teachers. You don't do that, only without doing it, you are doing it. But this is a complete answer to my judgment. My juniors have taken the responsibility. Normally I do not do it. I do not search so much whether this judgment was appealed again before the Supreme Court or not. They are saying no, because one cannot go. But we, being a human, we are susceptible to reasons. I may argue one thing, they may argue one thing, but ultimately we are susceptible to reasons. So according to me, this is the reasoning and rightly given by this division bench of the Kerala. The next judge. Oh, division bench of no. Just a minute. I normally try to follow this practice without giving copies to the other side. I normally do not hand up to the Honorable Court. This is 2006 5 CTC page 385. I'm going to pencil. Dag merechi tai pencil. 2006 5 CTC 385 special bench, Madurai bench, State of Madras. I'm sorry, the report online page. সব পাওয়া যাবে সিটিসি দুস্থবাদ তো কি করবো, এটা তো আমার মুশকিল হয়ে যাবে। আমি এখানে দাগ মেরেছি, ওকে দিয়ে দেন, এটা তুই পড়, ওটা খুব টেকতে দিই, আমি নই। মানে বিফোর প্লেসিং দিস জাজমেন্ট,
Yes.
Before they placing this judgment, I will place it in its entirety. Kindly allow me displace it, because it will take little time. One thing I submit before lordships, as I pointed out to your lordships, and this was one of the submission of Mr. Banerjee. Wrong surname bolchi na to Banerjee to Mr. Shivshankar Banerjee, that this concept or redeployment transfer of teacher on the basis of pupil-teacher ratio was even our 2009 Act was there, if I'm not wrongly understood him, right? And that's why 2002 rules. 2000, long before them, at least 8 years before the right to exam. This was in several states. This was the situation. And what was the interpretation giving to those rules? Well, because I have made one submissions after 2009 rules. Rule 3 and Rule 4 originally in 2002 rules do not survive. They automatically goes. Even if your losses hold that they survive the proviso, only proviso. 3 cannot, 3 has been substituted already, proviso. Even that cannot run counter to the Act 2009. That's the what I'm trying to, my lord, when this Act was not even born, 2009, these sort of government orders were there, or the rules were there. And those rules and government orders were interpreted by the court, honorable court, with reference to class, not the school. That's why I'm citing these judgment losses. So kindly come up your losses. Very vital. The question relates to teacher people ratio to be fixed in respect of elementary school. Elementary school, Malad Act defined 2009, but this is before 2009. From pre-primary to primary. The norm relating to teacher people ratio has been laid down in GEO number 525 school education dated 1997, which has been made effective from 1998. The norms relating to elementary school as per the said GEO are extracted here under. Number 1, elementary school. Kindly, the standard 1 to 5. The teacher people ratio 1:40 will be followed. Minimum 2 secondary grade teachers up to strength of 80 will be sanctioned. In respect of new schools, first post will be created in the first year and second post in the second year. One of the 2 posts will be in the grade of headmaster. B. For every additional strength of 40, 1 post of secondary grade teacher will be sanctioned, namely the 3rd post at 100, the 4th post at 140, the 5th post at 180, and so on. Regarding the bifurcation of the standard, additional section will be created when the strength exceeds 60 and so on in slabs 40. Pause here for a moment. Your losses will find, if I'm not wrong, the similar type of rules, little bit of different. 40, then 180, another teacher, 120, another teacher, 160, like this. A little bit of difference. And here one more thing, my lord. Standard means class that has been given by the court. Now, your lordships, the validity of such GEO and the difficulty in enforcing such GEO were the subject matter of the litigation. Ultimately, the division bench in such and such matter, while approving the stand of the government as reflected in the counter, had upheld the validity of the GEO. Then, your lordships. Subsequently, however, a clarification was sought for by the government by filing such and such, and at that stage, the division bench observed, paragraph 11, on a fair consideration of the entire matter, we come to the conclusion that as per GEO 525 of 1997, the teacher people ratio is 1:40. And only when the people's strength is at 80, second teacher's post will be sanctioned. Likewise, when the strength is at 100, third teacher's post will be sanctioned. And fourth teacher post at 140, and fifth teacher's post at 180, and so on. Then, paragraph 13 of the division bench observation. In the result, para 30 of the judgment is clarified as referred in paragraph 11 above. If the appellants have got any difficulty in teaching their pupils without having proper teacher strength as contended by them, it is for them to approach the government, and on such approach, the government is directed to consider the request that would be made by the appellants in order to provide quality education. Malad, here the appellant was the department. That's why court says, if the department feels that there is a dearth of teacher or the proper education cannot be imparted, then department has to approach the government. Then you'll see paragraph 5. Following the aforesaid clarificatory observation, it has been generally understood by the respondent that the teacher people ratio is fixed by taking into account the strength of the entire school. As my lord, if I'm not wrong, the case of the state. 6. Subsequently, a division bench of Madurai bench of Madras High Court in the decision of such and such observed in paragraph 15 of that judgment. In other words, if there are 5 standards, namely standards 1 to 5 in an elementary school, with the economic strength of not less than 20 in each standard, kindly see standard means class then, and each standard reaching 40 or 80 or 100 or 140 or 180 as this may be, the fixation of the teacher pupil ratio as prescribed in the government order will have to be made that would provide necessary teaching faculty to man each standard or class. Then Malad class wise. This judgment Malad of 2006 also. To put it differently, or to cite an analogy, if in an elementary school, there exist standards 1 to 5, and each standard the student strength is not less than 60, the bifurcation of the standard as prescribed under clause 1C will have to be made, and the required teacher pupil ratio at the rate of 1:40, with a minimum of 2 secondary grade teachers up to a strength of 80 for each standard will have to be maintained. Malad, I believe, Malad, my avehmence in the writ petition is so. After giving the factual background, the submissions from 26, entire 26 year lawsuits, 2 or 3 paragraphs deals with biological age, except that. If the ratio as prescribed in the GEO of 97 is not applied in the above said manner, that would result in total lack of required number of teachers to man the minimum number of pupils in each standard, which would ultimately result in great fall in the standard of education. And such a position can never be acknowledged or accepted as claimed by the respondents. Then your losses. The ratio of the subsequent division bench, as Malad paragraph 3 and 4, decision is to the effect that the question of teaching paper ratio will depend upon the number of standards and sections in the school. As I've stated, if it exceeds 40, there has to be creation of one more section. And we used to get it in our school life. I belong to class 5, but my section either 1 or 2 or 3. There are 3 sections. We are also come from Mafusil. There are 3 sections in each school. So, suppose one section getting teacher, other sections will not get. If they follow their standard, I follow. Standard means the procedure. If they go by the total strength, obviously that will happen. We are regarding the method you follow. One application makes the entire thing vitiated. Kindly see how this has been dealt with in this judgment. 8. Since such observation made by the division bench apparently runs counter to some observations made in WPA number, etc., disposed of on 9th November 2020, the matter has been referred to full bench to resolve the dispute. One division bench judgment is clear, 2006. Single judge hold like that. Division bench, was neither holding the, you approach the government. So entire matter referred to the special bench. Now, to say the least, the GEO number such and such of 97, particularly relating to the elementary school, is not happily worded. It is not very clear from the aforesaid instructions as to whether pupil-teacher ratio of 1:40 should be fixed on the basis of student strength in a particular standard or student strength of the entire school in question, irrespective of the number of standards in a school. If such government order is to be understood in the manner in which it has been projected hitherto, based on some observations here and there in WP number such and such, certain startling consequences will follow. Exactly this will follow. Come up here. If we accept the state affidavit. As is well known, elementary school consists of 5 standards. From standard 1 to 5. Probably in the other state, this is called standard. We say class. Education Act also states because all are from probably English medium school. Mr. Mojumdar will be able to say, because I am from Bengali medium school. I am from Bengali medium school native. I am also in the class. Probably they are from English medium school. They are believing in standard. I am not believing in standard, So, I'm not believing in standard. I'm believing in class, my lord. My lord said, I will take up to 4. Tomorrow, today I can't go on beyond that. Any eventual. No, tomorrow I will continue, losses. If losses keeps it tomorrow, I will continue.
No. You complete it by. We have already reached.
Well, this is one point I'm saying.
Till 4. So complete it by 4.
I'll try my
Mr.
best.
Bhattacharya will argue. He will argue. Then again, I have to come back to him because new points are being argued. Thursday it will not be possible. There are other matters there.
Wednesday with the chuti, na?
It's completed.
Let's see that তুই তো Thursday অসুবিধা আছে আমি দেখছি তুই একবার ঘুরে এলে পারলে আসিস kindly
Yes.
As is well known, elementary school consists of 5 standards from standard 1 to 5. If the minimum average strength of each standard is taken to be 20, which was assumed to be the economic strength as apparent from the case made out before the division bench, total strength of the school would be 100. And as per the arithmetic formula projected, the school will have 3 teachers. Kindly consider my submissions in the repetition and oral submissions. If the average strength of each standard is less than 20 and the total student strength is between 80 and 90, the school would have 2 teachers. Therefore, we have to imagine a situation where tenured children studying in different standards from standards 1 to 5 will have to be managed by 2 teachers if the strength is between 80 and 99, and with 3 teachers if the strength is between 100 and 139. It is indeed very difficult to imagine as to how 2 or even 3 teachers would manage as well as educate students of standards 1 to 5 simultaneously. It cannot be contemplated that any one teacher would be simultaneously teaching students of 2 separate standards or maybe even 3 standards. It also cannot be imagined that some periods will be off or some of the standards, in which event such children would not be under the control of any teacher, resulting in total chaos and the students becoming inevitable victims of unforeseen incidents. It is very difficult for us to visualize that while issuing such government order, the government had contemplated in the aforesaid manner. So meaning was given by the division bench in the next paragraph. The court of the view the government cannot visualize like this. The students will be lying idle. GO number 52/525 of was issued superseding earlier norms, fixing teacher-pupil ratio of such and such, and Rule 7 and 8 of Madrasa Education Rules is held applicable to both government and aided recognized primary school as per the judgment in such and such of 1999. Insofar as the Madrasa Education Rules, Rule 17 was applicable to the government schools, prior to the introduction of the present government order, which states that there should be 1 teacher for every standard and for every section of standards, in addition to the headmaster, excluding pundits and special teachers. Under Rule 18, no section of a class should have more than 40 pupils upon the roll. Even though the said Madrasa Education Rules are in the nature of administrative instructions, the apex court in the decision of Tamil Nadu and such were held that the field till 1st July 1988, when GO number such and such was ordered to be implemented. Therefore, what happened, my lord, though this was described at the rules, that was really an administrative instructions. Sometimes your lordships in our state also there are said rules, but those are commonly ROPA rules. We say ROPA is not a rules, the administrative instructions is not a rule statute framed by the legislature. Subordinate is rules. Administrative instructions. So that administrative instructions were substituted by 1997, which was the subject matter for consideration before the bench. 12. Similarly, so far as the private school are concerned, GO number such and such states that the minimum strength of any primary school should be 20. The second teacher will be allowed had the overall average attendance is 30 or above. 2 teachers if the average attendance of the combined standards is 30 and above. 3 teachers if it exceeds 55. 4 teachers if it exceeds 75. And 5 teachers if it is 95. 1 section in a standard if the student strength is up to 35. And 2 sections if the strength is between 35 and 70. 3 sections if the strength is between such and such. 4 sections in the section such and such. 5 sections in the section. It is further stated in clause 5 that the grant shall not be calculated for more teachers than there are standards of sections in the school and than actually employed in the school wherever is less. Thus, it is manifest that prior to issue of GO 525, each standard was sanctioned with a post. Division of standards are made in private school if it is more than 35 and government school if it was more than 40. The strength in one section is now increased up to 60. Even in the earlier division bench decision in paragraph 32, some conclusion was reached. A complete primary and elementary school must have standards 1 to 5. Each standard has got different syllabus to be taught. Kindly consider your losses. Each standard has separate timetable. Books are different during school hours, and therefore all the 5 standards there must be minimum 1 teacher for each standard. Kindly consider my paragraph in reply in 8D.
Yes.
Particularly when right to education up to the age of 14 years has been declared as fundamental right under Article 21 of the Constitution of India by the Supreme Court in the decisions of such and such. Mahini Jain, all are celebrated judgment, Unni Krishnan, and more particularly after introduction of Article 21A of the Constitution. When this was considered by the division special bench of the Madras High Court, Article 21A came to force, but not the Act, Education Act. Right. It was submitted by the learned Advocate General that validity of the GO having been upheld, the procedure in which is being followed on the basis of the observation made by the earlier division bench need not be disturbed, particularly keeping in view the huge financial implication involved. The question as to whether the government is bound to grant aid to any particular school is not before us. Even assuming that the government would sanction grant to all such teachers, we do not think the question of financial involvement can at all be an issue in such matters relating to primary education, particularly when the right to such education is now recognized as a part of the fundamental right in the shape of Article 21A of the Constitution. The obvious intention is to impart quality education wherever possible and not merely to pay lip service to such sentiments expressed. I'm going to pause here for a moment. Now, this has been entirely dealt with by the 2000 Act. Without maintaining infrastructure, you cannot recognize school even. All are aided recognized schools here. And you are trying to run it like this.
Yes.
We're in a better position because of the right to act. The learned Advocate General argued that because of the limited resources available to the government, the pupil-teacher ratio is modified from the original ratio and the teacher post are sanctioned based on ratio 1:50 after the strength exceeds 60. The contention that the limited resources or want of finance cannot be a ground to sanction lesser number of teaching posts to the schools, both in government and aided schools. Well, that's why, Malad, I have taken in the affidavit that you first recruit your teachers. Fill up the gaps. If we multiply the recognized schools number by 6, this will be the number of requirement. Here you are having the less. I can understand 10, 15, 50. But the lesser teachers are more than 2,000, 3,000 with reference to the number of schools. And you are redeploying. Everywhere the same situation will remain. The submissions for want of finance is the reason for revisiting the teacher cannot be counted in view of the settled position of Lamalad. I am skipping over this 16 because the views consistent that court cannot respond and state cannot come up with the financial limited source in regard to obligation of the performance of the constitutional obligation. State cannot. 17. It has been, that's why I'm just skipping over 16 because those two judgments have been referred since the learned Advocate General mentioned it. It has been submitted by the learned Advocate General that while interpreting the government order, the subsequent division bench should not have imported the principles relating to interpretation of statutes and particularly the ratio of the head-on case celebrated need not have been applied. The present case, GO number 525 of 1997, cannot be construed purely or merely an administrative order, but such order purports to lay down general principle affecting the system of primary education. Here, my lord, jural relationship lies. I'm taking my lord off the record. The entire, all are part of the primary education. All means, my lord, all the petitioners here I am confining to that. All, because all are primary teachers. It's a common relationship. Kindly take note of this one. In the question raised before the division bench was relating to proper interpretation of the government order. Since the meaning ascribed to such government order is likely to raise ambiguity and to uncertainty, obviously the court is required to step in to find out the real intention of the government order so that the general principle can be made effective and applicable consistent with the provisions in the Constitution. The further contention of the learned Advocate General is to the effect that if the real meaning of the government order was not ascertainable, but such order could have been quashed on the ground of indefiniteness or uncertainty, and there was no scope for interpreting or applying the government order in a particular manner. We do not think such a contention can be countenanced at the behest of the state. When the state government issues certain government order intending to lay down a policy in certain matter, and when there is an ambiguity in the said government order, the same should be interpreted in a reasonable manner to effectuate the intention, and there is no embargo on the court to apply the known principles of law applicable to interpretation of statutes. Learned Advocate General has further submitted that when a division bench decision was holding the field, the subsequent division bench should not have taken a view contrary to the earlier division bench without referring to the matter to larger bench. In the present case, on a careful scrutiny, it is found that as a matter of fact, the learned single judge who had initially decided the matter in the decision of such and such had not decided anywhere that while considering the question of tutor-teacher ratio, the strength of the students in the school, so as such, is to be taken into account. The number of standards and strength of the students in individual standards was immaterial. This was never held. That's why, my lord, the learned Advocate General submission was again discarded. And then, my lord, paragraph 21. The main question raised before the learned single judge was regarding the validity of the government order, and the learned single judge upheld the validity of the GO. In the appeal against such decision, the division bench had affirmed the decision of the learned single judge. As a matter of fact, a careful perusal of the earlier division bench decision, well, that's at paragraph 6 probably, makes it clear that the submissions have been made even by the government that the ratio prescribed was in relation to a particular standard and not of the entire school as a whole. And at some places, submissions have been made as if the student strength referred to in the government order related to the strength of the entire school. However, the division bench had nowhere categorically laid down while considering the applicability of the government order that the student strength of the entire school dehors the number of standards and student strength of the individual standard was to be considered. Even the subsequent clarificatory order had not categorically laid down as to whether the ratio has to be fixed only on the basis of student strength of the school or as a whole without reference to the students of each individual standard. It may be that such decision has been understood in many cases as if the ratio is to be fixed on the student strength of the entire school, but it cannot be concluded that the division bench had categorically laid down as a matter of law that the ratio is to be fixed on the basis of the student strength of the entire school, completely ignoring the student strength each individual standard. As a matter of fact, the subsequent division bench has only purported to interpret the GO in such a sense that it cannot be said that the latter division bench has differed from the earlier division bench. At any rate, the matter is now before a larger bench, and the real issue is relating to proper interpretation to be given. Then paragraph 20. As rightly observed by the latter division bench, the GO 5 to 5 has to be interpreted in a meaningful manner in keeping in view of the background in which the GO was come to be issued. As per the existing instructions applicable, the ratio of the teacher was dependent upon the student's strength in each individual standard, but it had been laid down that maximum strength in a particular section or a class should be 30 or 40. In other words, either no admission was required to be made in excess of 35 or 40, or if such admission is made taking relevant permission, an additional section was required to be created. In the context of the aforesaid background, the present GO of 5 to indicates that an additional section is required to be created only when the student strength in a standard becomes 60 or more. Kindly apply malad any of malad more particularly instances paragraph 8, 1 and 5 for excess students here. More excess.
Yes.
10 teachers were required. This is 7th. It is evident that the GO 5 to 5 has intended to change this aspect. And this is the reason why it has been indicated that when the student strength becomes 100, a third teacher can be appointed. If it has been understood that the ratio 1 is to 40 is to be maintained in respect of the entire school, it is not understood as to why it would be laid down in the GO that a third teacher would be available when the student strength reaches 100. Kindly consider this, how this is. Because meaningless it becomes otherwise. Students will lying idle. On the contrary,
in this state, when it is more than 40, suppose there are 60 or 70 students in a particular class, 40 is the limit. So you have one section and 30 goes to the other section. In your career, have you find any such proposal being floated from the school that I want a separate section in the school and the sanction strength is to be increased? Because without the sanction of a particular post, you cannot increase the section. So applying a principle that it is only akin to class wise and not school wise, without the strength being increased, it will also be a redundant approach on the part of the state to find out a make out proposal till the appointment is being made.
Exactly. That's my point. Even if I'm correctly I understood your lordship's observation. My point is that, therefore, there are two situations comes up. If it is follow school wise. Now suppose your lordships, each standard, if you standard or class for 6 classes up to 5 pre-primary and then 1, 2, 3, 4, 5. 6 classes. Now student strength is distributed among 100, total strength 100. Each having 15, 15, 15 and last one 25 or 20. Each students, but the student strength, suppose your lordship 6 today. You say 100 divided by 30, 40 or 30, then it be 100 divided by what they have done your losses by the total strength of the school, then it becomes to 3. But this, according to the class wise, to the teacher has sufficiently given, but you are withdrawing that. Then what will happen to the rest 3 schools?
District classes.
District classes, my son. They will be without teachers. That's the division special bench says also. So, Malad, this where I take your losses, Malad, one thing I losses. After the Right to Education Act, we can't have any say at all. We means, Malad, even the state. You have to follow this. Malad, in our school days, Malad, there are Malad off periods. When what we used to do, Malad, everybody knows. But that is not permitted now. That lackadaisical attitude is not permissible. You first do give the teacher. And that's why, Malad, if I'm not wrong, Primary Education Act says recruitment has to be made yearly. State has to be done yearly. Because of the requirement. Obviously, the state has to work out in a routine manner regularly. This is such a huge task. I appear for the board also. Often I submit, Malad, this much of teacher I don't require. That's why not requirement. When I make these submissions, Well, it's for the court to decide or to go into whether this submission based on what that data. Is it correct submission or is it wrong submission I'm making? This submission must be based on data. I do not require any teacher. Do you have the excess teacher in the pool? If you do not have, then how do I say it, my lord? What I'm trying to make some clear, dear lordships. My lord, student cannot sit idle. A teacher can sit idle for one class. In other way around. Student cannot sit idle. You have to impart education because even their act says under the standard how many periods you have to take, how many classes you have to take. A teacher, my lord, state cannot, my lord, say that I am paying teachers why he will sit idle for one class. State cannot say because this is primary education. You have to educate. This is your constitutional mandate. We have to consider like this, because when you want to give interpretation to the provisions, these are the constitutional goal. Teacher, students cannot sit idle.
Yes.
Then your losses kindly see. In a normal course, my lord, I left my lord after strength reaches 100.
Yes.
In normal course, the third teacher would be provided only when the student strength reaches 120, not 100. This is rather the indicative of the fact that the GO was concerned about the creation of additional section. If the student strength in a particular standard remains 60 and below, there is no necessity to create an additional section. And the necessity to create additional section arises only when the student strength in a particular standard exceeds 60. And that is why it has been stated that if the student strength is further increased by 40 more, another teacher would be sanctioned or would be required. The GO cannot be interpreted to do away with requirement of having at least one teacher for each standard or section. Wherever creation of additional section is justified. Let kindly take note of. Now, your lordships, the special bench sum up what they have decided. Keeping in the various relevant, we feel that GO should be interpreted in the following manner. 1. Ratio of the student teacher strength as indicated in GO should be primarily considered by taking each individual standard or section as a unit. That's my case. This is before 2009 Act. 2. The minimum strength of teachers required obviously should not fall below the number of standards or section in a school. Kindly apply to the facts of the case. In other words, if there are 5 standards, obviously the minimum number of teachers should be 5, and out of which one would be the headmaster. Headmaster is also a teacher, he used to take classes. Now a headmaster stays, they have to do the bazaar also for midday meal. I have that is already you have to do after school hours. You can't say. They have to perform. Midday meal are looked after by the headmasters. This is their additional duty. You have accepted the chair. You can't say that I will not do. So they have to do the bazaar. I have to give to the cook for the next day. And you have to do after the school hours. Then you ought not to have accepted the post of teacher, a head teacher. We can't say that. But your lordships, what is state? That if there are 5 units, 5 teacher must be there.
Yes.
Then 3. If the student strength in a particular standard exceeds 60, at that stage an additional section is required to be created requiring the sanction of his secondary section teachers, and the strength reaches 100, the post of a third teacher is required. I request your lordships apply to the school number 1, Paniyati Circle. Your lordships, I have dealt with in 8D's reply also, giving the chart also what they have done. Exact number of teachers, 10 teachers are required according to class unit. I have given your lordships above 40 number of students in 3 or 4 sections, for standard or class. That's to be treated as section. Now, if one says in one section keep 59, that's not against the law. That's against the law. You cannot keep it.
Yes.
then even after maintaining the aforesaid ratio by taking into account the student strength of each individual standard and an additional section, as the case may be, by keeping in view the teacher-student ratio is 1:40 of the entire school. If the teacher strength is required to be increased, the same has to be allowed. But in no case the teacher strength should be less than the number of standards, including the additional section. But even before Right to Education Act, this was observed by the special bench of the Madras High Court. Even before the Right to Education Act. In consonance with the constitutional goal as guaranteed under Article 21A. If more teachers are sanctioned, keeping in view the overall load strength of the school, the authorities of the school should create additional section in respect of the particular according to the need. Kindly pause here for a moment. This kindly give answers to your lordship's observations. Suppose the school head teacher finds 60 students in a particular class. He has to keep 40 and then rest 20, or he can do according to a 30-30, according to the room size or that. He has to do, and immediately has to inform to the council, give me the teacher. And that has to be provided. And that has to be done at the initiation of the year, not in the midst of the year. What we were doing in the midst of the year. Today we are now midst of the year, if I'm not wrong. Primary school January. Now from January to. So think over it before doing it. That's why I'm saying teachers are not slave man. If I do not perform, you have enough powers to take disciplinary action against me. But you cannot deal the teachers like this. এতটাই হবে না যশোর প্রেসারে আছেন যশোর তারপরে একটা মামলা এতক্ষণ নিয়ে নিচ্ছে না don't kindly listen to our internal submission because we are also appreciating your lordship is hard pressed, huge matter, motion bench, but it's such a matter it needs to be placed like this. Otherwise I could have summarized too much. Okay. If more teacher then additional post, this requirement is not only in respect of aided school or government school, but also in respect of private recognized school. Now pause here for a moment. All private recognized school is also under the Right to Education Act. Though this is not an issue, they have to maintain it. Otherwise their recognition will go automatically if somebody complains it. Because they fell short of the standard maintained under Rule 8 and Rule 9. For any school which requires recognition, it would be obviously open to formulate appropriate norms in consonance with the above observation and provisions of the Constitution. Well, this is not required 5 because Right to Education Act has come into force. Well, this I'm citing, that's why I'm again repeating, Malad, to deal with the pre-2009 situation. What has to be done, how the court interpreted the government action. And 2009, you lost is the other judgment division bench of the Kerala. No, to
Yes.
Just but one this judgment I'm citing এনেছিস তো না বলে তখন বিপদে পড়ে যাবে 2009 প্যারাগ্রাফ কত just no My lord, 2009, volume 1 SCC, page 168. My lord, this I am citing on the proposition. That's it is reported. এই একটা কপিটা দিতে না রিপোর্টেড
একটু দাঁড়াও ছুটে যাই বাড়িতে বই আনি।
তো ট্যাব আছে আমি নেই আমার নেই গরিব মানুষ আমি তো দেবো মানে প্যারাগ্রাফ 34 35 and 25 25 I just take your losses. I'm not taking the entire facts. I'm trying to be concise. Paragraph 25. We are constrained to confess
Yes.
that the case has left us perplexed. The stance adopted by the state of Maharashtra and the district collector is stranger than fiction. It is difficult to discern as to why they remain silent spectators without effectively participating in the proceedings before the court. No explanation is forthcoming as to why they have chosen not to file their replies to the writ petition in the High Court. However, in these appeals, the state government as well as the appellant have filed detailed affidavits disputing each and every statement and assertion of the writ petitioner made in the writ petition, opposing grant of any relief whatsoever to the writ petition. But even in this court, the state of Maharashtra, having filed its affidavit, did not participate in the proceedings and render any assistance in the matter. Then you lost it, paragraph 34. It would not be appropriate to dispose of the matter without any word about the conduct of the state government, reflecting a highly unsatisfactory state of affairs. We express our grave concern as to the matter in which the state has conducted in this case. It is the constitutional obligation and duty of the state to place true and relevant facts by filing proper affidavits, enabling the court to discharge its constitutional duties. The state and other authorities are bound to produce the complete records relating to the case once rule is issued by the court. It is needless to remind the governments that they do not enjoy the same amount of discretion as that of a private party, even in the matter of conduct of litigation. The governments do not enjoy any unlimited discretion in this regard. No one needs to remind the state that they represent the collective will of the society. The 2009 Act is that. Why I'm citing it, I will just explain to your lordships. Paragraph 35. The state in the present case, instead of filing its affidavit through higher officers of the government, utilize the lower ones to make oral statements, and that too through its AGP in the High Court. This malady requires immediate remedy. We hope that the government shall conduct itself in a responsible manner and assist that High Court by replacing the true and relevant facts by filing a proper affidavit and documents that may be available with it. We also hope and trust that the legal advisors of the government will display greater competency and attention in drafting affidavits. Why I'm signing, I'm sorry to cite this judgment also, but I have given in my paragraph 7, 8, and on the basis of that 26A to GH, what are my submissions with reference to the act and fact. But I may be wrong, assume paragraph 8 who I have given to a lawsuits. What was the state duty? To come up with actual figure that this is the petition wrongly given statements. These are not the correct state of data. This is the correct data. Have the state come forward? Or they have admitted it. So your lawsuits has no option to deal with it except on the basis of data. They have not stated in the affidavit what is the basis of declaring surplus. They have not disclosed the list, any list of surplus, the basis whereof would have got by the court. So this is the state responsibility. I'm questioning that. That's my issue. I lose or win, different, my lord. But what is your case in the affidavit? I do not find it. Yeah, this is the basis by which I prepared the list. I have given, my lord, as I have stated in my affidavit, I could not get the data because it was immediately prepared. So I've given it reply. So rest 3 you have, you could have said it, that look, this is only say your lawsuits admitted. I'm sorry to state also, they admitted that was also not happily said, my lord, happily said. like happily drafted. This totally admitted or halfly admitted or half-heartedly admitted. What is it? What is your basis? So, my lord, your lordship has to consider this is a pleading. Principle of non-traverse applies. Rather, it is admission. That's why I'm citing this judgment before lordships. যতটা পারছি করছি চারটে বলাটা পারমিট করছে now your lordships SOP the second point the SOP as I have submitted your lordships SOP directs to follow RTE Act for the identification. SOP never prescribes any method, never prescribes your lordships according to me, and biological age or joining date, that's only after identification for deployment or transfer of teachers. Now, SOP, your lordships, kindly have a look. Page 164. Now, as I have stated, your lordships, they are saying that these two SOPs are made under the geodated 10th July 2026, page 162. Twice they have stated, I have taken to your lordships in the affidavit, made they are under. Now, kindly have a look. These SOPs are made under this memo. One paragraph they are also saying this does not refer to any SOP. Then what stand should I take? I have to understand the stance. I will take your losses immediately. That's why it's take time. One paragraph they have stated that this memo does not refer to any SOP. Okay, fine. I have stated also. But 3 occasions in the affidavit you have said those SOPs made and they are under. What does it mean? This is affidavit. Kindly have a look at this. I will show on at least 3 instances. Then I will take. একটু বার কত ঘুমিয়ে পড়ছিস আতুল মাঝে মধ্যে মনে হচ্ছে হ্যাঁ যেখানে আমরা বলেছি অ্যাডমিট করছি আমরা কাইন্ডলি সি
para 15 para 15
para 15 para 3 kindly see para 3 first. They are denying. Kindly have a look. It is very outset, it is denied that the petitioners are entitled to any relief claim or the impugned memo issued by the Commissioner of the School Education or the standard operating procedure framed thereunder for identification. Kindly have a look. What is denial? The memo, the SOP framed thereunder means under that memo, or
yes,
the entire act, the entire pleading denial. What does it mean? They have stated anywhere. Kindly paragraph 15 also, your lordships, once as lordship pointed out. In the principal issue arising for consideration in the connect is whether memo number such and such 10 July and the SOP framed thereunder. One paragraph they say this does not refer to any memo. প্যারাগ্রাফটা বার কর এই তো দেখেছি ওটা তো বলে আরো ক্লিয়ারলি বলেছি যে kindly have your losses. I've got it. I've dealt with this also. Paragraph 10. Rest I will take your losses. As already stated in paragraph 8 and 9 of above, the memo dated 10th July did not itself enclose any SOP. The SOP was first communicated. What is the stand then? SOP may, who framed the SOP? Government. If the government frames it, my lord, I will argue that, and I have taken that point. And the writ petition also is non-statutory matter. If it is a frame by the government, state government, then this should be in the name of the governor. Otherwise, it doesn't have any effect. SOP. All these submissions, my lord, only with reference to the basis for transfer, not, my lord, the basis for identification of surplus teacher. That should be only under the Right to Education Act. You have said it also. This is only for the purpose of biological age or joining as teacher. This is the confusion. But before that, what your lordship pointed out, this does not refer to any SOP. 10th July. Kindly see, my lord, page 163. It refers to first and revised SOP.
Yes.
Yes. Now, your lordship, only difference your lordship says we have pointed out, and lordship has also noted that clause D, for consideration of surplus teachers, senior teachers in respect of the date of joining in the present school shall be considered first for. It is pertinent to mention that there is no such provision in the existing rules. That has been your lordships. In the next one, in the bold letter. This is revised according to the council. Now, my lord, kindly take up the affidavit in opposition. My lord, page 49, clause D, bold letter. For consideration of the surplus teachers,
Yes.
comma, senior teachers in respect of the date of joining in the present school shall be considered first for. For means according to my transfer. It is pertinent to mention that there is no such provision in the, my lord, existing rules for joining present school. There is no such provision in the existing rules, senior teachers or, my lord, junior teachers. My lord, kindly see the next. It may be replaced by the following. Then, for determination of the surplus teacher of a school, younger teachers shall be considered first. It changes entirely. For determination of the surplus teacher, biological age. It goes contrary to the Right to Education Act. And your lordships, kindly see, may be replaced. This annexure shows may be replaced. So this was a proposal. This was not yet replaced. Who replaced it? Council. Because council annexes it. They have annexed their, my lord, email with the council that this should not be disclosed or that or whatever may be. I mean, cut-sorting matter. Then who replaced it, my lord? The council. Then this was not framed by the, my lord, memo by the Director of School Education or Commissioner of School Education. What is the affidavit then? May be replaced by the following. So there must, when this was given effect to, there was no concrete decision of the government also.
Yes.
And kindly see, my lord, once D, originally for consideration of the surplus teachers. Rest, kindly see what is replaced for determination of the surplus teacher. Entirely changed, my lord. Determination means you are determining surplus teacher on the basis of biological age. But your chart shows otherwise. So what is your stand? What is your stand? But if it is biological age, then it's contrary to Act, Central Act. And that's why we have questioned it. as contrary to the Act and the Constitution. 2009 Act simply, my lord, enforces the obligation of the, my lord, central government under the Constitution. So kindly see, if I'm wrong, my lord, in reading that, that's different issue. For determination of the surplus teacher of a school and for determination of the, for consideration of surplus. The first one was right for transfer. Surplus determination, wrong, right, that's different. I have argued. You will decide it. But this is how could be done. This is one thing, my lord. I'm on this aspect, my lord. I'm showing you losses. But one point has been taken because I'm running short of time. This is an administrative instructions, SOP. They have said, take it your lordship administrative instructions. I'm showing one judgment, my lord. Administrative instructions is also a law. Kindly your lordships. 2023, volume 13 SCC. Copy to nahi. Just bar kori fatabat. Aage bar kor. 2023, volume 13 SCC, page 401. Paragraph 189. 401, paragraph 189 will be at page 505. At a pagination din na. Acha. Dicho. Di diche. Ote ami khule dichi facing di di. In paragraph 505, my page, I have given paragraph 189. Though the courts have been using proportionality standard to test the reasonableness of restrictions on fundamental rights after the decisions in Modern Dental and K.S. Putusami, this has generally been deployed in the area of legislative action. The position laid down by this court is that all violations of fundamental rights have to be tested on the standard of proportionality. The court under Article 13 of the Constitution has the power to declare laws that violate fundamental rights to be void. For the purpose of this the provision, law includes administrative action. Now, this is an administrative action. They say these are administrative instructions. This is an and any action, then administrative action. The position of law that administrative action infringing fundamental freedoms has to be tested on the proportionality standard has been established by this court in its earlier judgments that the action of MIB denying all that. But I'm on the proposition that this is law. If they say even administrative instruction, this is law. And if it violates any of the provisions of the Act, or it is unreasonable or arbitrary or unconstitutional, the court can interfere with. I am showing, my lord, on the face of it, biological age for the determination of surplus teacher, my lord, contrary to Act, Section 18, 25, and the schedule of the Act. My lord, 2019, volume 9 SCC, page 710. 2019, volume 9 SCC, page 710. কোর্ট গোল কিছু আনবে না, বালি থেকে আনা যায় আসে কেন হাইপোথেসাইজ मतलब 2009 volume 9 is 2019 volume 9 SCC page 710 बरकत paragraph 26 मतलब on the law if I'm because of shortage of time what I'm submitting both of my adversaries argued that this is a policy decision or this is an administrative action. This cannot be interfered with by this honorable. I'm on this proposition when administrative action. 2019 9 SCC, paragraph 26. Namalat kindly consider. Kindly 26. The challenge to the order dated 7th August 2004, by which the respondents were deprived of an opportunity of being considered for employment, is on the ground of violation of Articles 14, 19, and 21 of the Constitution of India. Lord Diplock in Council of Civil Services Unions versus Ministry of the Service has held that interference with an administrative action could be on the grounds of illegality, irrationality, and procedural impropriety. He was of the opinion that the proportionality could be an additional ground for review in the future. Interference with an administrative decision by applying the Wednesbury principles is restrictive only to decisions which are outrageous in the defiance of logic or of accepted moral standards, and that no sensible person who applied his mind to the question to be decided could arrive at. But I am saying, my lord, this is illegality because it violates the Constitution and Section 18, 25, and similar schedule of the Central Act, because it says on the basis of pupil-teacher ratio, it says for the permissions of surplus teacher, the revised one. Apart if philosophy at all, go by the revised one. 2009, 3 SCC, page 35.
পেজ কত বললে
2009 3 SCC page 35 paragraph 33 আচ্ছা আছে কপি আছে নিন তুই বার কর না তোর বইতে প্যারা 33 দর্শককে দিলি না Well, this is on the proposition that the policy decision can also be interfered with by the court, by the Honorable High Court. Paragraph 33.
Yes.
Page 53 probably also. Well, kindly see paragraph 33. Indisputably, a policy decision is not beyond the pale of judicial review, but the court must invalidate a policy on some legal principles. It can do so inter alia on the premises it is wholly irrational and not otherwise. The contention of the respondents that only 2 chances are granted for the consideration of the candidate to employ the power in our misconceived and the scheme is being one time could have been granted. But I am only proposition that it is not, my lord, it cannot be, it's not the rule that it cannot be touched by the court. If it is irrational, the court can. This is illegal, I have shown you a lawsuit policy decision. In respective facts, the court says in different languages. You cannot make a SOP contrary to the Central Act. Apart from what will consequence follow, my lord, from biological age, that I will argue also. 2007 4 SCC এগুলো ফটোকপি দিয়ে দিতে হবে তোর জজ স্যার কিভাবে কি করে হবে বই তুই নিয়ে চলে যাবি মানে I think your lordship kindly keep this one for your lordship's purpose, at least মানে make it lesser, but
7 SCC
2007 4 SCC 737 paragraph 16
proposition
ওই দেখাচ্ছি পলিসি ম্যাটার কখন কোর্ট ইন্টারফেয়ার করে paragraph 16 sorry 16 করে দে 17 বলেছি the scope of judicial review of government policy is now well defined.
Yes.
The scope of judicial review of the government policy is now well defined. Courts do not and cannot act as appellate authorities examining the correctness, suitability, appropriateness of a policy. Exactly in this line, Malad, their affidavit. nor are courts advisors to the executive on matter of policy which the executive is entitled to formulate. The scope of judicial review when examining a policy of the government is to check whether it violates the fundamental rights of the citizens or is opposed to the provisions of the Constitution or opposed to any statutory provision or manifestly arbitrary. But the first, my lord, this is opposed to the Central Act and the Constitution 21A. And arbitrary, obviously, if any violation constitutes, my lord, it's arbitrary. Apart from that, this is more arbitrary, I will show, my lord, in because of the biological age. It depends upon the facts, your lordships. In a particular judgment, court lays down this is the ratio, but ultimately in the facts held, no, there is no violation, therefore we cannot intervene. That's different. The proposition law, I'm saying. 2007 5 SCC. এটাও জসেফকে দিয়ে দিই, এটাও জসেফকে দিয়ে দিই। ও দিয়েছি, আচ্ছা এটা আসেনি। না, এত জুডিশিয়াল রিভিউ বলেছিলেন না, দেখি এটা কোনটা 5 to 4 5 to 8 এইটা 5 to 8 দাঁড়া একটু দাঁড়া, জট করিস না, আগে দেখে নি। তুই চাইছিস এটাকে লিঙ্ক করতে, আমি করবো না। না না, এটা ভুল বই দেখাচ্ছিস তো। 2007 4 SCC, না না 5 SCC তো। Just a minute, my lord. Sometimes I commit a mistake while preparing my brief. Paragraph 7. না, দুটো আছে কিন্তু প্যারাগ্রাফ মিলছে না কেন? No, but this judgment I will, my lord, I think I have committed some mistake in recording my brief. I miss
proposition.
Proposition, no. Proposition is, my lord, on this. Proposition is that, my lord, any scheme by of executive instruction or policy in terms of Article 162 of the Constitution, unless in the name of the governor's name and violates the Constitution, would be legally not sustainable. It should be in the name of the governor. My lord, I will cite that, my lord, I am missing it. I am placing them with the facts, my lord, I will cite that. I missed it. Kothao to mistake হয়েছে। হয়ে গেল? তার last judgment. তিনটে আছে? তোদের একটা দিলাম।
মাঝে মাঝে অর্ডার দয়া করছো কেন?
এগুলো দিচ্ছি যেগুলো অনলাইনে আছে এখন, আর যেগুলো রিপোর্টেড অনলাইনে। না বলি, মানে দিস ইজ
নিউট্রাল সাইটেশন দিয়ে দেবে, কারণ আমাদের অভ্যেস খারাপ হয়ে যাবে না।
This is in regard to, Malad, kindly see petitioner names Pushkar Singh Chandal and others versus. Malad, would you also permit me another day so that I can place it? Any day.
Other judgments also.
This judgment says, Malad, biological age. I can do it tomorrow, Malad. I can. If you lost
it, finish it
tomorrow.
Yes.
আজকেই বলছি,
আজকে
বেটার ডে দ্যান টুমরো।
আচ্ছা, কাজে পেরে উঠছি
না বুঝেছি, পেরে উঠছি না, অনেক সেটা বল, পারছো না ওটা
বলেছি। যখন বলেছিলাম চারটের পর আর করবো না, তাও আমি if you also permit me for the next day, any day, Malad. I want, Malad, your lordship, no, Malad, lordship will lose the thread. If you give me half an hour, I will conclude.
কালকে তাহলে 3টের সময় রাখো। 3টের সময় রাখো। তিনটে আছে আড়াইটের সময়
That suits me also. I will do it.
আড়াইটের সময় 2:30
3 3 o'clock. I will do it.
না 2:30 তে তাহলে বলবে
না না ওটা মিস আমি শেষ করে দেবো তারপর বলবো।
তাহলে এটা দিয়ে নিন কালকে জেরক্সটা নিয়ে আসবে আর Mr. Subir Sannal, learned advocate for the senior advocate and represent the petitioners in WPA such and such. ও এইগুলো নিতে হবে না রিপ্লাইস গুলো affidavit and reply filed in item numbers. Can you just provide the numbers of the writ petitions where the replies have filed? 1035. So replies, affidavit and replies filed in. দেখুন ওই ফার্স্ট এটা দাও ফার্স্টটা দাও ফার্স্ট এটা দাও যাতে সবগুলো আছে এটাতে রিপ্লাই আছে ওইটা দিন ওইটা দিন আমাকে ওইটা দিন today affidavit wait 19417 of 2026 Mr. Bose, you have filed your affidavit today? Previous day or this day? Today. 19417 of 2026, comma, WPA. 19720 replied today, fine.
Why like unreasonable?
All affidavits reply in the aforesaid writ petitions. Aforesaid writ petition filed this day is taken on record, copy served. Heard Mr. Subir Sannal, our senior advocate, who places his points of argument due to paucity of time here and conclusion. কালকে কখন কি আছে আমরা দিয়েছি 3 PM Mr. Sannal, where is Mr. Sannal? 2:30 tomorrow.
Milord, 2:30 thereafter, my lord, Mr. Majumdar possibly will get no time to address my lord. Milord, this again gets stretched because Wednesday is a holiday. Then, my lord, Thursday, my lord possibly.
No possible.
So, and I understand. I'm not saying that since they are enjoying the interim order, hence they are being elaborate. I not for a moment say that. But Lord, Mr. Sannal will have to also cooperate because last entire week, Lord, since Mr. Majumdar expressed his difficulty, Lord, I conceded. But Lord,
expedite to conclude that. That's why I'm placing one after the other day.
Yes, Lord. Hence, Lord, I'm saying if Mr. Sannal could be, Lord, prevailed upon to complete his argument.
Tomorrow I will.
I am not on date. I am on the time. But if it could be, Lord, in the first half, possibly Mr. Majumdar then Lord can take over. Yes, no, I
First half I'll be taking. First half I'll be taking some motion matters. That's why I'm placing on in the second half. You the points which have been argued by Mr. Sannal, you need not argue on that. If you have any separate points, you place that. Yes. Tomorrow 2:30.
Yes, my lord.
Mr. Biswas, you give the other judgments, the photocopy of which has not been given.
One judgment I have not given.
Yes.
No.
Thank you, sir.